May may it please, my lord. Prayer for listing of motion matters, my lord. Order has been issued by the Deputy Secretary, Personal Department, my lord. The capping date,
When do you want?
my lord, for tomorrow, my lord. My lord, my lord, day after tomorrow.
Okay, we'll try.
My lord,
Day after tomorrow, we'll.
my lord, 5 motion matters, but they are all connected, challenging the OM issued by the government regarding compensation appointment. They are all
Okay.
5 motion
Yeah.
matters. And
Hey, please, Lord. Back to mention a item for withdrawal. Withdrawal petition. Back to mention a item for withdrawal.
When?
Tomorrow or
May I please I beg to mention item number 22. I'm for a private respondent number 5. Second question from the I pay for possible for the
Respondent number?
item number 20. I'm for a respondent of 5.
Where is your name?
Hello, Digo. On behalf of Mr. Edward.
Learned Contempt. Yeah, the product. Learned Contempt number 5. The other side respondent. After
Responding.
diplomat. Please, Lord. Lordship, I beg to mention one admission matter, my lord. On Monday,
When?
my lord. 15th. Admission matter, my lord.
when do you want?
15th, my lord. Monday.
Next Monday.
Next Monday.
After vacation. Is there any urgency?
A long pending matter, my lord. This
Okay,
MSCP.
better immediately after reopening. Take it that from
One matter or it was last posted on 14/8/2025, and the respondents are directed that file an affidavit to bring on record the letter update. But they did not file the affidavit and the matter was not listed. May I pray for a date before vacation? Is it,
for vacation. Not for
Lordship, because it is a
Hearing
matter, no, admission matter, Lordship,
Admission
pertains to
matter after
Lordship,
vacation.
area salary, Lord. Area salary. Is a
Okay,
retired
after
person.
vacation.
A date. What is it? Late, Lord.
Before vacation, not for.
Then I will try to raise.
May I please your lordship? Lordship, may I make a prayer for the relisting of a matter? The matter had been pending for 6 months, your lordship, and the respondents have not filed their affidavit in reply. This is a matter pertaining to fixation of pay scale. Your lordship may kindly take up this matter on Monday. They have to file their affidavit in opposition. It's been 6 months, your lordship. Kindly, your lordship.
No, Monday, not for.
Lordship, Wednesday or
Already a
Thursday.
lot of matters have been taken for vacation.
Wednesday or Thursday would suffice, your lordship. Yeah, admission. Lordship, it's been pending for a long time. They have not filed their affidavit in opposition. Deeply obliged, your
May I
lordship.
please, your lordship? Lordship, I beg to mention item number 20. Lordship, when this
Already one person mentioned.
mention, I'm sorry.
May I please, your lord? I beg to mention for listing of a writ petition, my lord.
When?
My lord, petitioner after one and a half year, he
You tell me when do you want?
my lord, after vacation, my lord.
After vacation. Take it that from.
But item for the time being. Because the advocate conducting case, he is stuck up in the road due to heavy traffic jam. He will be coming within half an hour.
Already have served notice upon the other side.
Yes.
When?
It was last week.
Last week.
CGSC is down.
Can I please, Your Lordship?
Yeah.
My file is in outside only. Can I bring my file, Your Lordship?
Yes, yes, yes. You are referring for
All the respondents.
what sort of yes, what is your prayer, Mr. Sinha?
Oh, Your Honor, I have to save my college during my worst time of life, during my land grabbing time. I had handed over my accountable manager post to somebody else, and that land grabbing is now over. That received. Your Honor, this is like I'm challenging four orders. One is at page number 86. That is government's DGCA's decision. The College of Aeronautical Engineering and the proprietor, Lordship. And I have founded it in 2009. Since then, I am holding the post of accountable manager. In the eye of DGCA, the CEO or managing director, whatever, is called as accountable manager. So I'm holding that post being the operator. But during my worst time, I had handed over that post I have appointed to some one person. So he was accepted by the DGC. And when he was not maintaining the college proper manner, classes were not going on since January 2025. So I have removed him. And I have informed the DGCA that he is not maintaining my college. So I have removed him as a proprietor. Then they did not care to my any representation. Then I wrote to DZ, Director General of Civil Aviation, who is the head of that department. So I have given him a letter seeking for justice. Then that office also, the highest office also did not respond. Then I reminded him, send a reminder, and no communication from their side. Then I filed a writ petition before this honorable court. Immediately when they received that copy, next day they accepted my my communication that again I become the accountable manager of my college. Then all of a sudden I come to know that they have again appointed the previous my employee without my consent. Then I approached the honorable court, and honorable court had asked for their reply. But next when next day it came that honorable court has said that you have to have that order of that impugn order to be challenged here so that I can stay. That I have withdrawn that writ petition. Then I received those paper, that four orders, that is at page number 86, from 86 to 91. So I'm challenging this order. Your Honor, this college is the only college in entire Northeast in fact, entire eastern part of the India. So these college students are getting well established and they become engineer at different airline, different manufacturing, aircraft manufacturing company. In fact, our students are now engaged in their manufacturing at F-16 aircraft at Hyderabad. That is the fighter aircraft. Tata Lockheed Martin and Tata and Lockheed Martin is manufacturing F-16 fighter aircraft. Even up to that level, our students has gone. So it is a successful college of eastern part of India. And now I have to save this college, Lordship. And what DGCA is doing, without my knowledge, they are ignoring me. And it is a nexus, Lordship, that DGCA's one director, he is doing all these activity, reason best known to him. So this is the story, Lordship. As if like DGCA is the owner of this college. They are approving authority. I have not received a single rupee from anywhere. It is my hard-earned money. I have established. I am the proprietor, sole proprietor, Lordship. Trade license is annexed here with. And during my worst time last year, so DGCA, that officer, he was posted here in Guwahati. He guided me to accept accountable manager. You have to have some agreement so that as per CAR, Lordship, this is the CAR, Civil Aviation Requirement of Government of India. May I give it to you, Lordship? As per this CAR, Lordship, Civil Aviation Requirement of Government of India, Ministry of Civil Aviation, Lordship, that page number 5 says, Yeah.
Annexures are not properly marketed. You have
Lordship,
read to passing and setting inside annexure number 23, but the last annexure is 20.
that is wrong. In fact, that is annexure number 22 only,
Who
Lordship.
did it?
So the clerk must have done it. Annexure 22 only. There are no 23, Lordship. Lordship will find at page number 32, that Annexure 3, that is, I have appointed that person with whom their DGC officer is doing all these activities.
The person concerned was transferred from Guwahati to Odisha.
Purisha, Lordship. Without, I am the proprietor without my knowledge, Lordship. That is the biggest.
But you have already removed him from the post.
I have already removed him, Lordship. That is already mentioned in the page number 51, Lordship, Annexure 8. The Director of Airworthiness, Office of the Director of Airworthiness, LGBI Airport Guwahati, subject removal of accountable manager, training manager, examination manager, quality manager from the College of Aeronautical Engineering. Namaskar. With reference to the above subject matter, the undersigned has removed accountable manager, training manager, examination manager, and quality manager from their respective posts due to their illegal activity, irresponsibility to the student, and lack of knowledge and experience. The undersigned has been the sole founder and sole proprietor of this college since its establishment in the year 2009. The undersigned has appointed Dr. Sandra Das Panda on 29/4/2024 as accountable manager due to the ill health of the undersigned. Your office is requested not to entertain any communication or any proposal from Dr. Sandra Das Panda, accountable manager, including the present training manager, examination manager, and quality manager of this College of Aeronautical Engineering. The undersigned will propose a new set of people as per CAR, Civil Aviation Requirement, in very short time, which kind consideration is your kind consideration is highly appreciated. Thanking you. Vikram Hingalokar, proprietor and founder, College of Aeronautical Engineering. Lordship, then Lordship, I have nominated myself, that is at page number 53, Lordship, that is to the Director of Airworthiness, Office of the Civil Aviation Department, LGBI Airport, Guwahati. Subject request for acceptance of accountable manager. Namaskar. In continuation to earlier letter CAE so-and-so dated 2/5/2025, the name of the undersigned Sri Bikram Hingalokar has been nominated as accountable manager for your acceptance. Sri Bikram Hingalokar has founded this college in the year 2009 and has 14 years of experience as accountable manager. Sri Bikram Hingalokar has corporate authority for ensuring that all training commitment can be financed and carried out to the standard required by Civil Aviation Requirement, CAR 147 Basic. The corporate commitment by accountable manager 147.A.140 within bracket A so and so is enclosed herewith for your acceptance. This I have nominated myself as accountable manager, Lordship, and they did not given any response to me. That is why I have sent a letter to Director General of Civil Aviation, that is at page number 57. I have written here, the College of Aeronautical Engineering, Guwahati was established. Lordship.
Let topic go at this. Let her file her response.
Yes, yes.
Of course. Sorry, her in what capacity you are appearing?
CGC, Your Lordship. Your Lordship, one submission is there. His main grievance is against the new accountable manager, but he has not made him a party, Your Lordship.
Lordship, he was my employee, and I have removed him. He is no longer with me now. He has done all these.
He has to make him party, Your Lordship, because in his place, again, he has come here.
this matter of
Yes,
it under dated 25/6/2021 by the director airworthy and sanitary and sanitary also Annexure 20 the letter by the director airworthy here Kolkata has accepted the control of Panda as account of the was state was pardon
Sure.
in which year you have appointed Mr. Santodas Panda as your accountant
2024, Lordship.
2024. Panda as accountant manager
28 February 2000.
of the College of Administration of the proprietor and founder and government scientific Panda of accountant. When you have removed him,
Your Honor, it is that second 2/5/2025. 2nd May 2025.
2nd of May 2025, then informed about removal of Santodas Panda of accountant, the director of airwork, but in spite of the director of airworthiness has accepted Dr. Santodas Panda as accountant
May I,
and Office of Aeronautical.
Your Honor, again, I was accepted as accountable manager, Annexure 12, page number 61. Meanwhile,
Pardon, that the removal of Dr. Panda just appointed as the accountable manager and director of airworthiness has accepted the same by later dated
letter dated 24/7/2025, Lordship.
annexure
Annexure 12,
page number
page number 61, Lordship.
that this is the notice of the return of for it. How one of our methods entered a bit of how I started with the method after 4 may file our response.
oblige, your lordship.
This order may be stayed, otherwise there will be multiplicity of the proceeding. I'll have to again file because this government official is doing all negative activities.
Your lordship, let me get the instruction first,
This-
your lordship.
this
After
may
that,
be-
in the next day,
this may
your
be
lordship may
state,
consider.
Lordship. Otherwise they will do whatever they want, Lordship.
In the next day, your lordship.
Again, I will have to come before.
Better offline instruction, accept fair of the
Lordship,
Obligation.
this may be state, Lordship. It is,
accept.
then maybe next date may be fixed at short date, maybe. Lordship, it will be too late, and within this month time, they will do lot of other activities. Lot of other activities.
It will be after 4 weeks, your lordship.
Then, Lordship, it may be stayed. If it is 4 week or so, then it may be stayed, Lordship.
Let me file
I'll have
affidavit
to-
for sale.
I'll have to 24th September, Lord. Briefly
Obligation.
honest.
May please, bro. My lord, so far, cause list revealed, my lord, for referral to the special mediation. If so, my lord, better maybe refer to the
Can we refer the matter?
can refer. Because dispute arising in between the student and the principal regarding the student union fund. So,
Who is appearing for the principal?
Is it respondent?
that's 5.
Respondent number 5.
Yes, my lord.
Can we refer the matter to the mediation?
Yes, my lord.
Yeah.
Yes.
When you will be able to appear before the mediator? Before
According to your,
vacation or after vacation?
according to your convenience, my lord, you may fix according to
After vacation. After vacation.
After vacation. 15th of October. On that day,
During
the
vacation,
party
during
have to appear
after-
before the mediator.
Mediator name may be.
No.
Okay. Obliged.
I am agree. Agree for mediation.
Can be referred. Yes.
Your Lordship, I am for the State Bank of India, and the State Bank of India has got no stake in this matter. Only account is there, account of the petitioner is there. And their main claim is against the respondent number 6.
I am appearing for the
Insurance
respondent number 6 and 7, your lordship. SBI life insurance.
Can we refer the matter to the mediator?
Your lordship, in this case, your lordship, the thing is that we have repudiated the claim, entire claim of the petitioner, your lordship. Because at that time, because there was no disclosure of some facts were not disclosed at the time of taking the policy. That is our
That is
ground.
there, but
An attempt can be made in that case.
Pardon?
An attempt can be made.
yes. So when you will be able to appear before the mediator?
That's it.
When? After vacation.
Vacation, yeah. Interim may be continue. Interim may be continue.
Interim order for certain.
It is regarding of the pensionary benefits after retirement of pensioner or retired from service. But Lordship has passed this judgment. Analogous cases, Lordship case is covered by the judgment. Already submitted to it, like mark. Rupak Chandra.
Now tell me, can we refer to
Nothing will happen because
nothing will happen?
Lordship has already decided matter and passed this judgment in one case. 3 cases are pending.
So then we fix the matter for admission.
Lordship for disposal. Any date, Lordship.
Escape some order. Then you
A Waterpur for P Nayak for BTC.
appear
PT.
And you for elected part. So the matter is written under the column subject at the bar then purpose or by referring the very that it is the metaphor and on extent.
Lordship on the record that it is covered by your Lordship judgment. I like my
The day of hearing
public. Lordship fixed a date, Lordship, before Puja.
or addition yet or second
Before vacation, if possible.
Obliged.
none appears to be however
Lordship, I am appearing on behalf of respondent number 7,
your name is
Miss M. Das.
M the current number present. The legal date of after making in the event of subsequent non-representation
May I please? Lordship, an attempt can be made, Lordship, because the pension matter, it can be settled in their way.
when we
After vacation, Lordship, any day.
Mediation on the deeply obliged.
Please, your Lordship. No need to send for April. Parties are not agreed to.
not agree. So we have to decide the matter here.
On merits, Lordship.
Merit. Take it immediately after you can
Deeply obliged.
May I please, Your Lordship? My lord, I'm not sure, but this matter, my lord, perhaps wrongly has come in the, my lord, mediation column, my lord, because the matter relates to, my lord, leave encashment benefit of the retired employees, my lord. Now they are entitled to 300 days, my lord, but they have been given less than 300 days. The matter requires verification, my lord. In the same light, my lord, on a order I have annexed also, and another is, my lord, this is the order, my lord, passed by this court. Two matters together I filed, my lord. One is disposed of and this matter is pending, my lord. The similar order covered. Matter requires verification. If on verification, my lord, we are entitled, we will get, otherwise we will not get. So it will not do anything, my lord, in the mediation, my lord. They are single petitioner and in the instant petition, two petitioners, my lord.
the corpusary.
Can be disposed of, my lord, because he is claiming, my lord, the unpaid balance amount of his leave encashment benefit. Now maximum is 300 days. So the authorities will have to verify. The employer will have to verify, my lord. And here
Who is the employer?
employer will be, my lord, Director of Secondary Education.
Director of Secondary.
Thank you.
Yes. Does
Yes. It is there. Representation. Verify. It is.
of the petitioners are here.
There are two petitioners, my lord. Page 8 of my petition, my lord, I have given chart, my lord. Details.
Certain of financial hurt. Does
I'm appearing for
Secondary.
secondary education, 1, 2, and 4.
or yeah. It will direct pay or take salary for the period of 300 days. Similar to the employees of non-taking part by deducting the amount of their paid to the in terms of the subsequent order date 6, 7, plus in the 5, and as per office dated of the 12 part. The undisputed fact leading file the present petition is as both the petitioners were serving in the same school.
Same school, my lord.
Number 1 Abdur Rasid or Odora retired as assistant teacher of Gapari High Madras in the spring of Assam. After retirement, the petitioner was program event is opened in 30 days and the petition number event. The event is benefit for a period of 7 days. Then the 300 days after their respective their and in view of the judgment order dated 6/11 of the state and in of the dated 3 of the part the members are entitled to that pay the extent of 300 days as in other instances of not taking part. But the thing has not been that the process appropriation by seeking the next of getting to the purpose will be served by referring the matter to the mediation as the matter involves requirement of verification of documents and that equally depends on this the property connected with petition the or by order dated 8/8 directing the respondent or basically the respondent number 2 and 4 carry out necessary verification like the topic where the shall be paid the engagement on like hardly up to the maximum 300 days minus the benefit of the debit by the Mr. Further subset. Similar benefit, similar relief may be extended to the present of and the reason may be disposed of. If the product started nothing wrong with the finance department, does started of the secondary part also that of the by directing the of the and their pay the entitlement of the benefit on that are of the next of the minus the benefit of the pay of the pay to the taking of the burden the right by directing the for it the aspect of both the and therefore they shall be paid benefit on the earned up to the extent of 300 days minus the benefit of the day paid them. The exercise mentioned here in above shall be carried out 3 months the date of or the petitioner is certified to order applies the or especially respondent number 24 in a period of
Only one submission, my lord. The petitioners have not made any representation before the authorities. So along with the my lord, certified copy, my lord, let the petitioners also furnish the copies of the petition. Because
it is order provided that along with the certified order, the petitioner shall also enclose the copy of the petition and the annexer annex there.
I'm so obliged. Deeply obliged.
Wait, please, Your Lordship. Lordship, in this matter, my learned colleague, Mr. B. Kaushik, is conducting the matter, Lordship. And today he has some difficulties. He is not available in the court today, Lordship. The entire brief and record is with him, Lordship. Lordship, may fix immediately.
Lordship,
after
in fact,
the
on the last occasion, they had filed additional affidavit in one of the connected items, WBC 3879 of 2020. That was filed only in one item.
It will cover all.
If it covers all, Lordship, then we may be given the liberty to file a reply to this affidavit.
Lordship, that can be done.
So these are new facts which they have brought in for the first time by way of this additional affidavit.
Part
MDA.
M the E and part L product as a forma that is entered after by optic and after making
after valid.
forma order of the affidavit file
Lordship.
then Mr. does that it granted but response file is response the affidavit
Additional affidavit, Lordship.
It is an
It
additional,
is an additional affidavit.
additional
affidavit.
where it accordingly allowed the matter did the
Lordship may fix a date, Lordship. Lordship has kept it part heard.
okay.
Of
It's a
course,
legal
not mine, of mine.
part.
Lordship 27, Mr. Chaudhary will not be here. Mr. K. N. Chaudhary will not be here. তার পিছনে তার date detail, 29, obliged notice. Obliged notice. Disability.
He's here, Lordship. Mr. Dipivara is here. He's coming. I'm calling him. He's come. I let my senior start, Lord.
Already heard
Up to some length, today I am praying for taking up the matter for final disposal. For final disposal. Otherwise, the MBBS admission. Disability. He's here. I am. I had talked with him just few moments ago. He's there. My lord, may kindly for the peruse my certificate. I just taking up your lordship to page 19. Disability. Page,
for your disability certificate.
yes.
The disability is assessed at 40%.
That I am coming, my lord, one by one. My lord may allow only 10 minutes. I will complete my argument within 10 minutes. Here, your lordship kindly find this certificate contains certificate number and registration number.
Is number
19. One nine.
Yes.
So this certificate, my first submission is that, my lord. This certificate was issued in terms of section 57. Now, my lord, for a moment, kindly peruse section 57. Isn't it? Disability. 2016 disability. After Hidin on Asul. Right of Person with Disabilities Act 2016. The Right of Person with Disabilities Act 2016. ऊपर के थके वो लगे बड़ी सही से लेट करी चल Section 57. Here, Section 56 has provided guideline for assessment of specified disability. As per 56, I'll got it, man. Guideline would be prepared by central government. That is there. I am coming to that after a few moments. Now, designation of certifying authority. So, certifying authority is appointed and they are to assess the disability, and after assessment, certificate is to be issued. Procedure for certification, 58. So, this three section is vital. Here, 56 says guideline for issuance of certificate, assessment of disability. 57 person who would be eligible for issuing certificate. Who is the certifying authority, issuing authority, and procedure. Now, your lordship will find rule
rule to this act, man. Is Rule 18. This is called Right of Person with Disabilities Rule 2017. Rule 18.
Yes.
This rule has prescribed the procedure for issuance of a certificate. On receipt of an application under such and such, the medical authority or any other notified competent authority shall verify the information as provided by the applicant and shall assess the disability in terms of relevant guideline. Now, once again, 56 come into operation. In terms of guideline issued under 56. Now, these are the guideline. In my book, your Lordship is holding the same book, then page 115. Here the guideline for the purpose of assessing the extent of specified disability.
Provided in the rule.
Guideline. Rule says as it will be as rule and act says it will be as per guideline. Assessment would be made as per guideline.
That guideline is mentioned.
The guideline is called, my lord, guidelines for the purpose of assessing
Where it is mentioned.
In 56, section 56, your lordship will find government shall notify guideline. 56 says government shall notify guideline. So guideline is there. Issue of rule says on receipt of application under such and such, competent authority shall verify the information as provided by the applicant shall assess the disability in terms of relevant guideline.
Yes.
Now guideline. The petitioner in this case is locomotor disability. Now what are to be assessment? My lord, got the guideline. The caption is guideline for the purpose of assessing the extent of specified disability in a person included under the Right of Person with Disabilities Act 2016. Definition. Got it.
Here it is also guideline for the national award.
Now, guideline for the it is also known guideline for the purpose of assessing the extent of specified disability.
It is provided in the rule.
No, specific guideline is there. Rule says as per guideline. Act says as per guideline. And the guideline is given in this book, my lord. These are the guidelines. Act says as central government will prepare a guideline. Rule says the as per guideline prepared by the government, assessment has to be made. So this guideline has been made. It is immediately after guideline, after rule. Immediately in my book, after immediately of National Trust for Welfare and then guideline.
Their guideline for national award, the empowerment of disability is there. That guideline.
There are 2-3 guidelines. It is for assessment. What I am relevant in this case is that guideline for assessment. There are another guideline for providing accommodation. This is another guideline. So this is not relevant in my case. My case, what is relevant is guideline for assessment. আসলে কন্টেন্ট অফ সাকশন আছে নাকি, না থাকলে তো বিচারই না পাবো। Here relevant clause I have marked. These are the procedure for assessment. Now, in the meantime, my lord, another aspect of it, I am the
Yes, guideline for evaluation of.
yes, I have marked the relevant portion how to assess.
Yes.
So, in my case, that is not done. There is no mention. The assessment on the other day, my learned friend has submitted that after assessment, my disability was found 15%. So my humble submission is that the certificate issued to the petitioner is in accordance with the section 56, 57, and 58, read with rule 18 and as per guideline mentioned here. And it is valid for lifetime because it is valid issued after 18 years of age. So there is another provision in this act, my lord. Here it is provided that if a certificate is issued to a disabled person on attaining 18 years, that means it is permanent disability.
Whether the authority can re-evaluate the same.
So this is my one aspect. Now the another aspect, my lord, your lordship, kindly for a moment peruse the paragraph number 4 of my writ petition. Sorry, my lord, paragraph number 3. Paragraph 3. 4 also relevant, but paragraph 3 will do. Page 6.
Yes.
Paragraph 3. That the petitioner has been suffering from 40% disability from supracondylar fracture with mild malunion. Therefore, he comes under expression person with benchmark disability as expressed under section 2S, read with section 34 of Right of Personal Disability Act 2016, and entitled to get benefit of 3% reservation in higher educational institution as provided under section such and such hereinafter referred to as Act. So this is my main contention in this. Now, my lord, affidavit in opposition file. Your lordship kindly peruse paragraph 4, page 28 of the affidavit in opposition. Rule 2. Page 28, paragraph 4 of the affidavit in opposition. I have got it.
Yes.
That as regards statement made in paragraph 1, paragraph 2, 3, 4, 5, 6, 7, 8, and 9 of the writ petition, your deponent offers no comment. My lord, got it, man. So, statement, this is my main contention in this writ petition. That has not been denied. Your lordship, kindly note this my submission. Now the entire plea of the respondent is that as per 2017 rule, on that point I already argued on the first day, and I have given it, my lord, it is in the record. There, a person has to be suffer 45% to 70, in between 45 to 70%. So since I am found 15% not entitled, this is their basic contention. So my argument was that the schedule to the rule 17, your lordship kindly, but this is in the record, my lord. Here, Government of Assam, the 1st July 2017, the rule was published prescribing procedure in 2017, 1st July. That is the first page that I have given, my lord. So, as per this rule, 2017 rule, I have marked the page number, my lord. Your lordship will find page 29 of the rule.
Yeah.
Page 29. Here, clause N for news, N. It is correct. Their pleadings is correct. So far it is made, so far it is concerned to the 2017 rule, 50 to 70%. Page 29. Between 50 to 70% shall be eligible for quota. I got it, my lord. Now, what is there, my lord? Next page, your lordship kindly page 30. Page 30. I got it.
Yes.
This notification has been published on 13 March 2024. 13 March 2024. And what is the content? The Governor of Assam is hereby pleased to make the following rules. Further, to amend the Medical College and Dental Colleges of Assam regulation of admission into first year MBBS and BDS course Rule 2017, herein after referred to as the principal rule, in the manner herein after appearing namely. So the 17 rule by 13th March 2024 has been amended up to some extent. 17 rule is the principal rule. That is there in the 24 rule, amended rule. So 17 rule provided 45 to 70. Now what is provided in 24 amended rules? Only schedule. Therefore I have annexed the schedule. Schedule 3. Your lordship will find column close Q, page 37. Column Q, my lord, got it, man. Page 37.
Page 37 of their affidavit.
No. This is the rule I have given to your lordship. On the other day, it is in the record.
value.
আগত থাকি মই দিছো আছে ৰেকৰ্ডত থাকিব লাগে on the first day I have provided one copy yes ওলাই ৰাখিছিল নেকি
Perhaps you have taken it like
no I have not taken it back it is came up before your lordship and it is there because I had an extra copy this is with me
they have enclosed it as annexure being there available. Is it a notification of 3rd of July 2007?
yes but this is for therefore they have said as per 2017 rule disability percentage must be 45 to 70 and it is their case and I am since found after assessment 15% not eligible now for 24 rule this is amendment 90 এটা উলাই দেখো তারপর উলাই দিব হ্যাঁ
24 breaking.
government government of Assam the notification will take 13 months of the এইটো MBBS amended rule 24 এনেকা মাৰি দিয়া আহিব নেটত আহিব this 24 amended rule says there is now it is not a question of percentage is specified disability now the new
Where is that?
মই দিছো কপি কোর্টের কপি তো আর আমি চেক করার কথা না MBBS amended এইটো দিক মই দিছো close queue now close queue says specified disability এতিয়া মোৰ কিতাপখন দিব পাৰিবনে এটাতে স্পেসিফাইড ডিসেবিলিটি চাও লাগিব am I clear my lord close queue it is said specified disability because the X says specified disability percentage is done
Yes.
now what is specified disability that is there in the act has defined specified disability that is section 2(3)(z)(c) section 3(z)(c) specifies in the schedule. ZC says specified disability means the disability as specified in the schedule. So schedule has specified what are the specified disabilities. You. Light হৈছে এইটো তাক দিব পাৰিবা নে সেই ওলাই দিব তুমি লৈ লৈছা ডাউনলোড কৰি আছো Am I clear, my lord? As per 2017 rule, the requirement was 45 to 70%. Now the rule has been amended in 2024, and after amendment, now the existing rule is a person has to suffer from specified disability. Am I clear? Yes, sir. Now, specific disability has been defined in section 3ZC. It is said specific disability is as per schedule. Now, schedule is at the last of this act, after section 102, the schedule specified disability. Section 2C, ZC says, as per this schedule, what is there, it will be assessed as per the schedule. Now, specified disability, my case is, my lord, 1A Roman I of the schedule. My lord, got the schedule, man. Loss of sensation in hand or feet, as well as loss of sensation and presses in the eye and eyelid, but with no manifest deformity. You see? So there another plea is that my disability scenes on the upper limb, rule only provide that only disabled only in lower limb will be entitled. This is their another case, but law does not say so. So that finding is also against the, my lord, contrary to law. This is my another submission. It is close queue. Now, my lord, my next point of argument is there, my lord. The principal rule, that is 17 rule. 17 rule says there now guideline provides, my lord, guideline as your lordship already got. The assessment should be made by a board, medical board. In my case, only a single doctor has assessed my disability. There is no constitution of board, board of experts. My lord, It will apparent, my lord, in the affidavit, affidavit in opposition. Your lordship kindly peruse the affidavit in opposition. Page 72, last page. They picked up one specialist for one department. This is not the criteria, man. Your lordship will find that Dr. Such and such HOD psychiatry, Dr. Such and such HOD orthopedics, Dr. Such and such HOD neurology. So my case is neurology. Dr. Such and such HOD ophthalmology, Dr. Such and such HOD ENT, Dr. Such and such HOD hematology, Dr. Such and such uh, PMR GMC assistant professor such and such. So one doctor, this is not a board mind. This is not the way of assessing disability. A person comes under neurology, they are in neurological disability. He has to be assessed by at least two experts.
Where it is provided?
Board. In the guideline, it is provided. Assessment should be made by a board. So
Guideline.
board means, it my understanding.
You show the guideline where it is provided.
Board is, my lord, page 63 of my affidavit, my lord. The board is there, my lords. Page 63 of
No, I have to form
page 63, my lord.
as per part. একটু বলছি আপনি কইছে ঠিক আছে তো আমি কই
In which rule it is provided? In which guideline it is provided? That
It is also part of the rule, my lord.
Part.
Rule, my lord. Admission rule 2017, my lord.
rule says there should be an expert committee. The rule somewhere is there. 17 rule, no? What to put? No, no, what is the Yes, my lord. It is there in Rule 17. It is annexed. They have annexed in
Page 63.
50. Page 63. Addition affidavit in opposition. That is 2017 rule. The DME shall constitute a medical board consisting of not less than 3 head of the orthopedics department of the Medical College of Assam of the Medical College of Assam or their representative not below the rank of Professor of Orthopedics Department for assessment of disability of the student seeking admission. So at least 3 rule itself says not. But here only one doctor. One, your lordship, I have already referred to the page. Only one orthopedic. So category of disabilities, your lordship, is already there in the schedule. There are 7, 8 categories of disability. So in each to assess the disability for each category, at least 3 experts. Here, government, what DME has done, they have picked up all head of the department of various departments. This is not the procedure as laid down as per rule. And so far upper limb and lower limb, this is not there in amended rule 2024. So this is my lord argument before your lordship, my lord. For this, my lord, lacunas, my lord, the assessment, my humble submission is that, my lord, is they have not done in accordance with law, my. Rule is framed by the government of Assam. 3 expert rule is not the central rule. It is the rule of state government. And they itself has violated their own rule. So I am relying upon, my lord, to judgment of the Supreme Court, my lord. Basically on the point that the percentage, so far the percentage is concerned, whether 15%, 20%, 30%. This is not the criteria to be laid down. And because rule has said percentage is not a matter now. Whether they are to assess whether a person who applied for the admission under the 3% quota, whether he comes under specified disability or not, that point has to be ascertained. But in my case, that point has not been ascertained. They have ascertained, what ascertained is my percentage, and that too by a single doctor expert.
Yes, Mr. Bora. If the rule provides for assessment of the disability by the orthopedic professor, then why the board is not constituted in terms of the rule?
My lord, the board has been constituted as page 64, your lordship will find, my lord.
It is there, but where 3 orthopedics professors are there.
Yes, my lord. Not less than 3 head of the orthopedic department. My lord, orthopedic, there must be only 1 head of the particular orthopedic department, but other departments, my lord.
Is it,
Because there may not, it cannot be 3 head of a single department, my lord. Because the constitution of the board, your lordship will find at page 64. All the members are, my lord, HOD, head of the department.
That's all right, but it is in terms of the rule. It comes to page number 63 of your affidavit.
Yes, my lord, I understand, my lord. My lord, probably it means that, my lord, or they are not below the rank of professor of orthopedic department. The medical board constitution. Because the orthopedic departments, because normally, particularly, it should be a department, orthopedic department. But
medical colleges of Assam, that means more than 1 medical college.
yes, my lord. Orthopedic department, probably the orthopedic departments include these literally, my lord, the other departments also, because normally, my lord, the disability is of other departments also, because only the orthopedic doctor, literally, orthopedic doctor cannot examine the disability of other, like eye or other, because my ophthalmology or specialists from every department will be required, my lord, to assess, my lord.
Now tell me whether the board was constituted in terms of this rule.
Yes, my lord, because if your lordship sees the types of disability in page 32, my lord, because the types of disability, so to examine all these type of disability, my lord, these specialists are required. My lord, the HOD of psychiatry, HOD of orthopedic, HOD of neurology, ophthalmology, ENT, hematology. So these are the specialists required to determine or examine the different types of disability.
That's right, but in the rule it is provided that the head of the department of orthopedics of the medical colleges of one is there, the other two head of the departments are not there.
Yes, my lord.
Can we say that the assessment was done in terms of the rule?
My lord, if your lord,
When the last date for examination, last date for admission,
my lord, the second round of counseling is starting from tomorrow. Second round of counseling, my lord. Tomorrow. Yes. So if your lordship wants, then I can clarify this issue, my lord, from the end. Your lordship may take up the matter tomorrow, my lord.
counseling,
No, this is apparent, my lord, in the record itself. I have no question about the about the efficiency of this doctor. Every doctors are in different field, and your lordship will find the type of disabilities has been mentioned here. At least 10.
let him know.
Tomorrow, my lord. Yes. Yes, ma'am.
But yeah, you did turn it on for the safety for on the health department. Which for respondent number one? You are for
Respondent number 1, my lord. Yes, my lord.
alter.
Yes, my lord. All the respondents.
Third in part is the method for us to obtain respect of constitution of the medical board in terms of clause 4.1 small line
Of Schedule 3.
of
Schedule.
the city
of the rules of 2017.
of the sector. What have applied the list of books
Hello?
before argument well in advance. This list of book you realize of
Citation.
regime after 5.
Yes. Obligement.
The last occasion I was having on my affidavit, that was not on record. It has come on record, my lord.
Today it is available.
Today it is available, my lord. It has come on record. Last, it starts from page number 74 on.
Yes. What is your
But,
observation?
well, what my friend is speaking upon that, there are three analogous cases which are disposed of by order dated 29/5/2017. He also similarly situated, that is, he lot, my friend has action page number 35 onwards. And the 49 is the 11th paragraph, my lord, where the direction was given to the director and the commission secretary to whether these people comes within the ambit of the Assam pension rule 1969 or the new pension scheme of 2005. What you will see, my lord, in my affidavit, my lord, after the order dated
They have been regularized with effect from 2007.
with effect from 2007, my lord.
And
So that's that.
therefore, according to your reason, they are not entitled.
They are not entitled, man. In fact, a committee was looking at page number 28. In fact, a committee was constituted by 3-member committee.
But we are not concerned with their findings. The
Committee has said this
their service has been
service has been
regularized.
regularized with effect from after
Regularization order has not yet not been cancelled or withdrawn.
done. That is regulation on.
Yes.
So they have order dated 4/9/2013, my lord. It had come into effect. Their regulation has come along with other persons, 27 other persons, with effect from 27 to 2007. The moment regulation come after 2001, 2005, my lord.
Why, the Bora, not the, why the case of the petitioner is not covered by the decision rendered in this copy of which enclosed by him.
Yes, my lord. Therefore, my lord, they were there was a direction to the authority to make whether they comes under this old pensions and new pensions. That's why a committee was constituted, man. page number 78. They have, the committee was constituted.
But Mr. Bora, there is a division of division bench of this court.
Yes. And
where it is stated that if it is stated that oh, the process of recruitment is initiated prior to the bench of law, then they would be governed by the full bench of law.
there,
Here, not only they have been appointed prior to 2005, but also
the appointment, but there no substantive post, no on a substantive post, or there is advertisement. They were only in the stopgap when they continuing.
that is not the issue before this court. The issue is only whether they will.
They will come in that new pension scheme, the old or the old pension scheme, my lord.
Yes.
In fact, my lord, there are subsequent development after that also, my lord. The petitioners in the writ petition, writ petition, they also have filed a contempt petition, my lord, saying that this has not been followed, my lord. Thereafter, the consequential order has been also been passed by the secretary, the government of Assam education department, rejecting their pay also. That is also there, which is not. This is the recent development, my lord. It is 25th June 2025.
The Bora, who filed the contempt?
Not the present petition, other petition. He is relying on that petition, my lord. Other petitioners have filed a contempt petition. That was also closed, my lord, in view of this particular order, my lord.
I rely on 3 persons, Lordship, who are similar to me, Lordship. There are 34 numbers of persons who are regularized, Lordship. Amongst them, Lordship, 4 are similarly situated. He has got a real.
Yes, Bora.
If Lordship takes up that, subsequently the contempt petition also closed with the order dated 25/7/2025, my lord. The detailed order has been passed. Contempt petition is 211 of 2018, my lord.
Any other point?
So this is the point, my lord. That's why, my lord, since there is a, if Lordship even comes to the impugn order, page number 30, very fast line, my lord, page 30, that order dated 4/9/2013, in persons of government letter number so and so, which was concurred by the finance department, white order number so and so dated 17/8/2003, and persons to the honorable high court order dated writ petition. These are the petition I have this connect, my lord. The ad hoc service of the following 34, they were ad hoc, my lord. 34 employees under the director of SCRT are hereby regularized with effect from 27/3/2007 under new pensions. So it is pursuant to a government order decided. These were all ad hoc employees. They were never regularized with effect from this particular order dated 4/9/2013 with effect from 27/3/2007. This have been ordered. They have been regularized. So all along they were ad hoc employees. They were not serving in a substantive post. They were there. There was no selection process. They were only.
No, Bora, you cannot perhaps deadline because their regularity is done as per order of this court.
Yes.
This order, interim order by number WBC number 434 of 2013 and 63 of 2013. Ad hoc services of following 34 employees under the directorate of NCRT Assam are hereby regularized with effect from 27/3. So, this regularization was done as per the direction by this court.
Yes.
Now, perhaps you cannot argue on that one.
All along they were ad hoc employees. They were regularized, my lord.
That has already been adjudicated by court.
Lordship will see. This is not. Lordship will come to the original. This is the typography error, my lord. I will show it, my lord.
Original of
Original Lordship will page number 32.
30?
32. Next page, my lord. There is type copy. There are two repetition is shown, including the repetition number 63 of 2013. And Lordship, that repetition is the next annexure, my lord. That is, it starts from that it's on page number 35. That is the repetition. Lordship will find that 63 repetition in page number 38. Repetition number 63 of 13. Because there is a typography error in the particular page, my lord. This is the order.
35 is not the repetition mentioned in this order.
My lord. Lordship.
WBC number 434 of 2013.
434 and
is a WBC number 476 of 2013.
No, Lordship will kindly see the original one, page 32. WPC number 434 and WPC number 63 of 2013. 63 is 2013, page number 38. This is the order dated 29/5/2017. Some traffic, maybe some traffic error. 63 is there. 63 of 2013. This order dated 29/7/2017, my lord, page number 40 onward. Yes, 434 is also there, my lord. Okay. Page number? Page 39, it is there. Yes, my lord. Page 39 is there. 434 of 2013. Page 39, I have missed it, my lord. Page 39, it is there. Pursuant to this order dated 29/5/2017, this order has been passed, my lord. Order dated 4/9/2013.
And since it was done as per direct by now,
Yes, my lord. Pursuant to Honor High Court order, this has been regularized with effect from 27/3/2007.
any other
So these are the points, my lord. My final substitute is in the court of hand.
study
Means they were ad hoc. They were ad hoc appointment is ordered really clear. They were never regularized. They were regularized with effect from 27/3/2007 by order dated 4/9/5. And they cannot be since they were continuing as an ad hoc employee. They were never regularized earlier. And this is pursuant to a government order and a financial conference was given. Thereafter, they were regularized. With a date which is after 1/2/2005, so they will fall under new pension scheme, not the old pension scheme.
whether the earlier rule is provided that they will not entitled to benefit
Yes, sir. That
under the old scheme because of their services.
yes, sir. That on the page 39 onwards in the page 30 in order on the second below, my lord.
Page?
Below page 30 in that particular order type copy, my lord. 30 in the non below, my lord. This has cancelled the earlier order issued where memo number notice dated 28/10/2011. The concerned employee must submit the undertaking as per prescribed format as a member of the new Assam Pension Service Pension Rule 2005. They have to give an undertaking.
Provided in the old rule that the purpose of their ad hoc appointment, their ad hoc appointee, their full pension.
No, they should have a substantive post. They, through advertisement, they should have appeared before them. In the very fast examiner, they were never.
Did it provided in the rule? Earlier rule.
Because appointment lordship will find in page number 15. It's clearly stated that the person is an outsider. He has come into picture without any advertisement, no selection, and then he continues. So to accommodate him, another he has made as a laboratory assistant.
Your affidavit, point number 4.
Malad affidavit dated 21/7.
Yeah.
This is the committee.
4. Paragraph number 4.
Malad.
Somewhere in the middle,
Good.
candidate employee was appointed on ad hoc basis for 4 months of advertised election, and the ad hoc services time to time.
They were ad hoc appointed. The very first page number 15 makes it absolutely clear they are appointed ad hoc, and they continue time to time. And only because of the government, there is an order from the government that, and subsequently the High Court order, they have was taken into consideration and they were regularized with effect on a certain date, 27/3/2007.
My point is whether the ad hoc appointees are not entitled to pension.
They should hold a substantive post, not sanction.
It is
And only
provided in the rule.
No.
Both pension
I'm not holding that particular pension rule, but it says that rule 31 is that they should hold a substantive post. Substantive post they should hold, my lord. Only they will get a pension, my lord.
Yes, Sir Talukdar.
Lordship, Rule 31, Lordship. 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 As per that, Lordship, I am entitled, Lordship. As per Rule 31, Lordship.
Employment must be
Substantive, yes,
permanent.
yes, Lordship.
Under 11.9.
I will explain to that, Lordship. To that effect, Lordship, there is a judgment passed by this Honorable Court, that is Kobiram Rajbangshi. Lordship. Kobiram Rajbangshi says, Lordship, even in case of master roll laborers, Lordship, those who were not at all regularized, directed the state to create a supernumerary post for 1 day regularization, that is prior to the date of retirement, Lordship. even if a person is regularized prior to the date of his retirement, Lordship, he is entitled to pension. His past services are counted, Lordship, as per Kobiraj Rajvanshi, Lordship.
What is that?
So Kobiraj Rajvanshi judgment is not with me, Lordship, and I can furnish it. I can furnish it. It is a reported judgment, Lordship, and any kinds of services, Lordship. I was the counsel for more than 100 cases, Lordship, of master and workforce employees who were not at all regularized, Lordship, and their services were regularized for 1 day, that is either before the date of regularization, the date of retirement, or before the date of Lordship, Lordship. And thereafter, Lordship, after 1 day regularization, their past services were, Lordship, counted, Lordship, after deducting few sums, Lordship, 3 years, Lordship. To that effect, there is
How with that?
global,
That judgment now?
Lordship. And Lordship, moreover, Lordship, very recently, Honorable Supreme Court has on, Lordship, 19 August, Lordship, a very good judgment has been passed, Lordship, with regard to ad hoc employees, Lordship. May I read the first paragraph of the judgment, Lordship? Here, the Honorable Supreme Court, Lordship, started from the first paragraph. When public institutions depend day after day on the same hands to perform permanent tax, quality demands that those taxes are placed on sanction posts and those workers are treated with fairness and dignity. The controversy before us is not about rewarding irregular employment. It is about whether years of ad hoc engagement defended by shifting excuses and pleas of financial strains can be used to deny the rights of those who have kept public institutions running. We resolve it by insisting that public employment should be organized with fairness, reasoned decision-making, and respect for the dignity of work. With regard to ad hoc employment, very good judgment, Lordship, on 19th of August. And Lordship, moreover, Lordship, my learned pay may not go to the pleadings of my case, Lordship, properly, Lordship. If your Lordship come to the page number 38, Lordship, 38, WBC number 63, Mukunda Deka. Then, Lordship, page number 39, 434, 2013, Homeswar Kolita, 39. Then, Lordship, may come to the page number 51, Lordship. These two petitioners are similar. Their sanctions are same, Lordship, and pension have been granted to these two persons, Lordship. Page number 51, Lordship. Petitioner of petition number 63 and Lordship, petitioner of petition number 434 have received their pensionary benefits, Lordship, which I have annexed at page number 51. And with regard to Lordship, that Lordship, I rely on a judgment passed by the Honorable Supreme Court, that is State of Uttar Pradesh versus Arvind Kumar Srivastava, Lordship. Here the Honorable Supreme Court says about delay losses and similar relief, Lordship.
For a similar
Yes, 51, Lordship.
The copy is not so eligible, my lord.
Yes, 51.
This 51 is not legible, my lord. My friend is even worse than me.
Not legible, my lord. Unable to read anything. Decision. Regularization and consequences. Yeah. Right. In my reply affidavit also, Lordship, I annex this letter, Lordship. Page 73. No, not page 70.
Page 73.
73. 73. Second August 2022, Lordship.
Page number, paragraph number.
No, Lordship is page 73 of my reply affidavit, Lordship. Letter from the secretary to the director, Lordship. And followed by that, Lordship, page number 51.
Reply page number.
73, Lordship. Page number 73. And as a consequence of that, Lordship, page 51.
Yes.
Lordship. Lordship, in inviting a reference to your letter on the subject cited above, I am directed to convey no objection of the government in elementary education department towards the pension regarding regularization of the ad hoc service period and counting of past services for the purpose of computation of pensionary benefits only and allowing pension and other retirement benefits under Assam Service Pension Rules 1969 to Sri Mukunda Deka, Laboratory Assistant, Assam, and Homeshwar Kolita, LD Kam Typist, under Directorate of SCAT Assam, in compliance with the Honorable High Court's order in WBC number so and so and WBC number so and so, Lordship. And thereafter that 51, Lordship. And Mukunda Deka and Homeshwar Kolita were similarly situated, Lordship. We work all together, Lordship. Earlier, our services were regularized in the year 1994. Thereafter, again, we were, Lordship, temporarily appointed, Lordship. Sanctions are also similar, Lordship, same. I will furnish Kobiram Rajbangsh's husband, Lordship.
No, my lordship, I'll show it, lordship. Page 32. My friend is showing this Mukundo Kam Kolita and Mukundo Deka and Homeshwar Kolita. They also is covered under that particular order, my lord, of 4/3/49/2013. Lordship will come to page 32, the original copy, my lord. Homeshwar Kolita's name is shown in serial number 13. And Mukundo in 21. They were also regularized with effect from 27/3/2007. Their name figure in that particular order, my lord, which is changed.
I only typed out the 11% only. 9, 10, 13, 17,
Yes,
21.
they also figure. They also services regulations comes into effect from 27/9/2017. Yes, 27/3/2007. 2007. So they cannot leave, we cannot say that they also come on the same equal footing, my lord.
Drafted the whole thing,
Lordship, Lordship,
as per 51.
51 Lordship.
Oh, order, Lordship will, page number 51, Lordship will see the page number 32. Page number 6, Mr. Nolita's name also figure.
That's all right.
That is my case, Lordship.
The same that they were regularized, but Mr. Kolita has been drafted the benefit in the present denied the benefit.
And then subsequently the issue will come, my lord, that, that whether they have given the undertaking and that deduction has been made in the new pension scheme or not, my lord. That instruction I have to take, my lord.
That's the way of granting the
And followed by the division bench order, Lordship, state has taken decision to grant Lordship pension under the old pension rules, Lordship. And to that effect, Lordship, a letter has been issued by the Secretary Finance Department, Lordship, on 20th January 2025, Lordship. Process of regularization here, Lordship, was started in the year 2004, Lordship. Screening committee constituted, page 25. On that count also, Lordship, I am entitled to pension, Lordship.
Lord,
uh,
Lordship. Commercial Kolida. I have an act, Lordship, 51, page number 51. Commercial Kolida, 51, page number Kolida.
Yesterday, you have submitted that you will produce on 6.
yes, sir.
Lordship.
Few moments that you have submitted that you will produce on 6.
Kobiram Rajbangshi, I will furnish. Not only that, Lordship, I will furnish the compliance order, Lordship. One day regularization, how one day, after one day regularization, parcel is entered.
Produce the same.
Lordship. Tomorrow, Lordship, I will.
Okay.
But I will also take the instruction. Finance.
For day.
My lord.
For 13 part is the matter for Thursday. Father.
Lord, sir, I will also take the instruction whether this, for the regulation of order dated for 4 and 13, my lord, whether this contribution is there to the new pension scheme or not, my lord. Because this subsequently the Home Circle has the order dated is 22/8/2022. After he was in the list on 2013, subsequently it has come in. Lord, sir. Lord.
Bless you. On that particular day, may I submit one written argument, Lordship? On the
You can.
Lordship. Bless you.
After some time, senior was here. He just kept.
I please, Your Lordship. Before my learned friend start, I want to make one prayer, Your Lordship. Lordship, actually in this matter, I am led by Mr. R.M. Das, Your Lordship. R.M. Das, Standing Council Social Justice Department, Your Lordship. Actually, today he is suffering from high fever, Your Lordship. He could not come, Your Lordship. If Your Lordship permits, he will make his submission on next Tuesday, Your Lordship.
Yes, yes.
Yes, I have no objection, my lord.
Or Mr. Professor, Madam,
Ardeka.
or take a learned content. Take a subject led by RM, who is absent today. Also be there. Where is the
Yes, part.
Obliged.
May I please, Your Lordship. My lord, this matter pertains to provincialization of service of the petitioners, my lord. I am agree with the impugn order, Lordship will find at page 97 and Annexure 24, my lord. Lord, the only ground of rejection of my claim was that in the year 2016 and 17, my lord, there was no enrollment in the school, my lord. And on last occasion also, my lord, I referred to one specific page, my lord, page 84, my lord. There is an inspection report, my lord. Page 84, Lordship will kindly have a look. This is an inspection report, my lord, pertaining to the year 2017, my lord, 5/5/2017. This was conducted by the SIO school, Procedural Circle, Nagaon, Assam, my lord. And if we count the number of students, my lord, it becomes 160, my lord. Therefore, the findings of the, my lord, concerned director, my lord, is not correct. And what happened, my lord, during the, my lord, pendency of this petition, my lord, Lordship had directed me to produce the, my lord, concerned, my lord, applications, my lord, pertaining to release of my dias code, since there was a dispute between two schools as regards genuineness of the school, my lord. And by virtue of the speaking order, my school was declared to be the genuine school. That is a part of the case record, my lord. And thereafter, my lord, I have already, my lord, produced the other applications, my lord, regarding the, my lord, release of the dias code or to issue a fresh dias code, my lord, from the concerned authority. And in this regard also, my lord, the concerned authority, my lord, Lordship will find at page 96, there is a communication, my lord. Page 96, my lord. The dias code, my lord, this is a, my lord, communication made by the, my lord, DO, my lord, Noga, my lord, to the mission director, my lord. Page 96, Annexure 23, second last para, my lord. Dias code may either be renewed or issue a fresh dias code, my lord. This was made on, my lord, in the 21/3/2017, my lord. 31. And regarding the, my lord, last inspection, my lord, the concerned, my lord, department, my lord, they have submitted, my lord, one additional affidavit, my lord, instead of, my lord, affidavit in opposition, my lord, which I received on 25th of, my lord, July, my lord. And they said that they had conducted one inquiry, my lord, and I admitted that on the day of inquiry, my lord, I had to remain absent along with my brother, since one of my relative, my lord, he had died, my lord, he succumbed, my lord. This is admitted fact, my lord, as your lordship is well aware of that. And today morning, my lord, on just, my lord, 1 hour back, my lord, we have received one affidavit in opposition filed by the department, my lord. They have admitted this fact, my lord, that there was no prior notice which was served upon the petitioner, my lord. And they're taking the same stand, my lord, that they had conducted the inquiry and there was no one in the school, my lord, neither the students nor the teacher in the school, my lord. Therefore, my humble submission before your lordship is that affidavit may not be required in this petition, my lord. Lordship will be pleased to decide this case, my lord, by today itself, my lord, basing upon the materials before your lordship, my lord. The stand taken by the director.
Lordship.
That cannot be.
May I please, your Lordship? Lordship, the matter is attached with Mr. A. Foucault, Standing Council, Elementary Department, and due to his medical problem, Lordship, he is unable to attend the court. So, Lordship, may I please your Lordship to fix the matter on Thursday?
My lord, same stand taken, my lord. The only thing is that they have admitted that there was no prior notice which was served upon us. Same thing, my lord. The contents are almost same, my lord. identical. Then Lordship will kindly fix it. Thursday, my lord.
Yes, but oh, oh, but but yes, oh, yes, that's correct. But about oh, Thursday, yes, partner.
My lord. If
Yes. Ma'am. My lord, I'm appearing on behalf of my senior. The matter may kindly fix after 1 week or 2 weeks.
Your good name, please.
Yes, Your Honor.
Your name, please.
Rasmin Sultana.
That
Rasmin Sultana.
job of job of
Santosh Sharma.
yes, yes, check this up. 1 week or 2 weeks.
2 weeks. Bless.
May I please, Your Lordship, this matter regarding to the non-payment of arrears salary, my lord. But here, my lord, what happened, my lord, they have filed the affidavit. We have also filed the affidavit, but my lord, my clerk has committed some mistake, my lord. The copy has been served to the elementary education, my lord, in spite of him, my lord. My lord, I will serve the copy on, during the course of the day. Accordingly, my lord, matter may be taken up on next week, any date, my lord. Because, my lord, already, my lord, too many time has gone, my lord. It is admitted fact, my lord. Already, principal has submitted the proposal before the director to consider my case, my lord. That has not been considered.
Okay, or the Purdua Garnet.
It is
But by reply to the affidavit, but but uh, but 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 yes, furnish a copy of the that of the or by yes, therefore that or a copy of the but that is after one
my lord, if possible on 19, my lord. 19, nothing already all at 17. It will oblige your lordship. Oblige.
May it please your lordship. Lordship, can you take the matter at 2 feet?
Lordship,
At 2, lordship.
at PM, I have gotten another case fixed and court number 7 in series matter. At it will be difficult.
Lordship, then after some time, lordship, after 2 and at 3, at any time.
when
Today, lordship, there is an urgency, lordship.
At it will be difficult with the series matter in court number 7.
about time
It cannot be
After the
because some this is regarding selection appointment of in central armed police process and diseases are there, and honorable court has categorized it that skin disease will be taken up at 7 o'clock and sorry at 2 o'clock. So at there are some matters of fact there, those of skin disease at 2 o'clock.
lordship, can you take
Yeah,
the matter as last item, lordship?
we'll try if possible you come.
Yes, but
Otherwise, we will adjourn the matter.
yes,
But anyway, we'll call the matter.
but yes, as and when I get to I'll.
Mm.
Okay.
May I repeat, my lord? Sir, 26 and appear, my lord, the contempt matter. It's a long pending matter, my lord. The contempt is filed on 2024. The series of order has been passed, my lord, but they have not implemented the order. And my lord, this litigation started from 2016, my lord. Till now, my lord, there is a case, my lord, regarding the regulation of service order petitioner, my lord, and lordship by order in 19, my lord, asked them to, my lord, to regulate my service. Instead of, my lord, regulate my service, they were giving my fixed pay. Again, I filed another writ application. In that case, my lord, because earlier order is there, my lord, only to consider the earlier, my lord, earlier, my lord, payer, my lord. But after that, I filed application. They have, till now, I have not filed it, not implemented the order. Now they have filed, my lord, they review of it order. The review earlier occasion, last occasion, my lord, their lordship has said that the review is not, my lord, entertained. Because, my lord, because Uma Devi case, my lord, if person is working, my lord, more than, my lord, 10 years without intervention of the court, my lord, in that case, my lord, that case, my lord, there is no question of his service to be regularized. In this case, he appointed on 1985, my lord, working, my lord. I finally said 2016, my lord. Order is there, my lord, even that they have no implemented order. Now, my lord, they have come with a, my lord, plea, my lord, that this is, my lord, barred by limitation. And they have already, my lord, one case of the Supreme Court. I have filed one case, that is our High Court, that case, my lord, in Article 250, my lord, there is no question of any limitation. Thereafter, they file another case, my lord. The Supreme Court, that is, my lord, three judges decision, they follow up state case. But I have gone to that case, my lord. That case also, my lord, the Supreme Court has not said that 2000 Article 215 order cannot be abrogated or stultified, my lord. That some decisions have been made, my lord, as regarding that, my lord, Article 226, my lord, certain rituals to be followed, my lord. If that follow-up state case also state, my lord, certain rituals should be said. If a person is, my lord, say property matter, in that case, my lord, question of limitation will come. I immediately after the Lord, kindly see, my lord, immediately after the passing of the order, I have last order, my lord, that was passed on, my lord, 16/12/2022. I filed an application on 12/22/2022. Thereafter, on 5/7/23, my lord, the container asked me to appear for a hearing. I appear, my lord, but they have not taken any action. Thereafter, I filed a writ application. The follow-up state.
No, the review petition is preferred by the state.
No, state, my lord.
Yes.
That case, my lord.
You were ready to argue the matter.
Lordship will keep it the review petition later on, my lord. First, the Lordship will kindly see the last order, my lord. Last order date 25/7 of the contempt petition, my lord. 25/7/25. This is absolutely making it clear, my lord. The order of the court was 16/12/2022 and the contempt petition has been filed on 11/1/24. It will straightaway hit section 20 of the Contempt of Court Act, limitation. They should have come before the court within a limited period of 1 year. And argument has taken place on the particular day, my lord. This is a forwarded slide on my friend as well as myself, my lord. And the Supreme Court is absolutely clear, my lord, that when there is a Contempt of Court Act will prevail and section 20, if it is filed after a delay of 1 year, my lord, section 20 limitation will come into play and that contempt petition cannot be entertained. No, they wrongly. Kindly see down that follow-up state case. Kindly see what paragraph 30 has been said. That paragraph 30 and, my lord, 32 original period is there, and paragraph 41 clearly says, I have doubted the decision, my lord.
Which case?
That follow-up state, my lord, is reported to 2001 7 SCC page 549.
Is part of the record?
Well, there are 3 cases. Myself have given 3 cases. These are main case, my friend. This is decision by 3 judgment decision. Kindly see that is the judgment, my lord.
Yes.
Kindly see, my paragraph 30, my lord. Paragraph 30. What's paragraph 30 H3? May I read, my lord? Paragraph 30.
Yes.
That there can be no doubt that both this court and the High Court are courts of record, and the Constitution has given them the power to punish for contempt. The decision of this court clearly shows that this court cannot be abrogated or stultified. But if the power under Article 129 or Article 215 is absolute,
can there be any legislation indicating the manner and to the extent that power can be exercised? If there is any provision of law which classifies or abrogates the power under Article 129 stroke Article 215, there can be little doubt that such law would not be regarded as having been validly enacted. It, however, appears to us that providing the for quantum of punishment or what may or may not be regarded as act of contempt of even providing a period of limitation for initiating proceeding for contempt cannot be taken to be provision which abrogates or qualifies contempt jurisdiction under Article 129 or Article 215 of the Constitution. And this paragraph said, my lord, this power under Article 215 cannot be abrogated. Next paragraph, kindly see, my lord. It says, paragraph 31, this court has always frowned upon the grant of access or existence of the absolute or unbridled power, just as power or jurisdiction under Article 226 has to be exercised in accordance with law if any enacted by the legislature. It will stand to the reason that power under Article 129 or Article 215 should be exercised in consonance. Kindly see the word consonance with provision of validly enacted law. In case apparent or likely conflict, the provisions should be construed harmoniously. If there is a conflict, my lord, this should be construed harmoniously. Here it says that the power cannot be taken away because of the act of the parliament. But lordship kindly, any mind of power of the constitution can be taken away by the act of the legislation, my lord. Next, kindly see. Kindly turn to my lord. Paragraph 34. Paragraph 34. As we have already noted in the bill which was presented to the Parliament after taking into consideration the recommendation of the Sunlight Committee, there was no provision initially. Kindly see, no provision similar to Section 20 of the 1979 Act. It is only in the Joint Parliamentary Committee which recommended the insertion of Section 20 so as to provide for period of limitation. There can be little doubt that Section 20 as framed is not happily worded. The heading of that section, however, indicates that it was to provide a limitation for contempt. The wording of the section is negative, but it's clear that terminus ad quem is in the initiation of proceeding for contempt. The question that arises as to how and when are proceeding for contempt initiated. Initially, but Section 20 is not there in the contempt. Subsequently, my Joint Parliamentary Committee has inserted this provision, my lord, and this Supreme Court has said, my lord, this word is not good. And kindly see, my lord, if even then, my lord, this power is not absolute, my lord. Kindly turn to, my lord, section phrase and paragraph 41, my lord. Paragraph 41. One of the principles underlying for law of individual is that litigation must act vigilantly and not to slip over its right. In this paragraph,
paragraph number?
Paragraph 41.
Yes.
One of the principles underlying the law of limitation is that a litigation must act diligently and not slip over its right. In this breakdown, such an interpretation should be placed for Section 20 of the Act, which does not lead to a anomalous result causing hardship to the party who may have acted with utmost vigilance, and because of the inaction on the part of the court, a contender cannot be made to suffer. Interpreting the section in the manner canvassed by Mr. Venugopal will mean that court will be rendered powerless to punish even though it may fully convince of the blatant nature of the contempt having been committed, and same has been brought to the notice of the court soon after the committed of contempt and within the period of 1 year of the same. Section 20 therefore has to be construed in a manner which would avoid such an anomaly and hardship both as regards the litigant and also by placing a pointless pressure on the part of the court to punish his contempt. And the interpretation of Section 20 like one canvas an appellant which will render the constitutional power of the court regulatory in taking action for contempt, even in case of gross contempt, successfully hidden for a period of 1 year by practicing fraud, and by the contemptor will render Section 20 as liable to be regarded as being conflict with Article 129 and Article 215. Such a rigid intervention must therefore be avoided. But this judgment has not said anything, my lord. Power can be taken by Section 20 of the Contempt Act, my lord. Even after the order passed by this court, my lord, I immediately file an application. Kindly see, I file an application on last order of passed on 16/12/2022. Thereafter, my lord, Annexer 3 page 22 on 12/12/2021. I have filed an application to inform the content of both 1, 2, 3 regarding the passing order. Thereafter, my lord, Annexer 4 page 23, my lord, on 5/7/23, Container 3 asks me to appear with the document before him for hearing. I accordingly appear, my lord. Where I step over the matter, my lord. I am vigilant, my lord. If after a passing order, I slip over the matter, the question is different. Immediately after an order, I am my lord, first my lord, written file 2016, order is passed 2019. Thereafter, my lord, order was say, my lord, instead of my lord, regulation, my service has been, my lord, fixed has been given. Thereafter, second petition has been filed, that this order has been passed. Immediately, I oppose 16/7 order 22 16/12 order has been passed. After 6 days, my lord, 22/12 to 22, my lord, I have filed an application. Thereafter, they call me for the office on 5/7/23. That is Annexer 4 page 23. I appear, my lord. Where is the, my lord, negligence, my lord? Where is the, my lord? I am not vigilant, my lord. Yes, madam, absolute power. There is any absolute power, but that does not mean that they have not done anything, my lord. Now they come with a plea that because it's barred by limitation under section 20 of the Contempt Act. But kindly see, my lord, can a constitutional power taken away by the act of the parliament, my lord? And my Supreme Court has one distinctly stated in the paragraph, the power cannot be, my lord, taken away. Power cannot be absolute, my lord. And second is, my lord, reasonable time may be given, my lord. I have reasonable time, my lord. Where is my diligence? When I have left in my power to approach the, my lord, contemner after passing the order. Section 30. And now they come with, my lord, we say, my lord, review of the application along with my and raise this point, power present, question limitation, my lord. It's everything in a record, my lord. Can you see, my lord? In 2016, my lord, I am fighting for this, my lord, my right, my lord. I am working since 1985, and they have not been regularized my service. Some person appointed with me, they are serving regularized. I have stated in my petition, my lord. Now they after, my lord, when order has been passed, they have said, my lord, they come with a new plea, my lord, that is barred by limitation and want to, because I have been appointed on compensation ground for no question of, my lord, regulation of service. Whatever Uma Devi case, my lord, Supreme Court clearly stated, working 10 years without international court, in that case, service is regulated. So my humble prayer before is, my lord, at least, my lord, the poor people, he is sweeper, my lord. Where shall I go, my lord? See, I will approach the highest court of the state, my lord. Where shall I go, my lord? Ventilate my right, my lord. And they come a new plea, my lord, and they have delayed the matter. Can you see, my lord, from 2000, a series of order has been passed. They have taken time for filing on a, my lord, review petition. Can you see the order? Various order for they only file in when I give in the petition, they file this, my lord, review application. Now after filing the review application, they come with a plea with the barred by limitation. And our High Court has been 2000. That is also before your lordship, my lord. That is distinguished, my lord. Our High Court order has said, my lord, in case of petition under Article 215, my lord, question limitation will not come. But after this,
With the radio at 4 o'clock. So, Borough, what is your expect?
My stand raised to also in contempt. There is a delay, my lord. So it will hit section 20. If all of that case makes it absolutely clear, my lord, that section 20 when it hit, that contempt petition, it cannot be entertained. There are other two decisions also I will place it. But in the same time, review petition will be filed because in the original order, my lord, the petitioner had been shown as appointment on compassionate ground. In fact, the petitioner is not appointed in a compassionate ground. It was only with when a post is right vacant because the person who has father has left that particular job, he was straight away inducted in that particular job without any selection.
Wrong statement has been made, my lord.
Well, I will put it more.
Wrong statement.
I will show it, my lord.
I
will show it. Paragraph number, my lord. He has stopped leading paragraph number 44 and 45, my lord. No.
Please, your lordship.
Yes.
Before break my subject, my lord, although the power under
Both these matters are listed in the column order. Should we hear the matter today?
then not fix the date, my lord. The only thing my lordship consider my learned friend has placed one decision that my lord follow state case. That my lord that follow state was clearly distinguished. That follow state case was clearly distinguished, my lord. The section 20, my lord. Although section 20 is not my lord, absolute, my lord, but that power cannot be taken with the. Although this power is not absolute, my lord, like under Article 226, my lord, certain limitation is there, my lord. But regarding that exercise, this power, my lord, certain limit is also there. But what are the limitations should be well exercised? Please mention in paragraph, my lord. I mentioned it paragraph 30, 31, my lord. 31, my lord, 32, 33, 34, 41, my lord. A reasonable period of time is there, my lord. Lordship kindly see, my lord. Reasonable period is there, my lord. Section 30, my lord, kindly see. This is regarding, my lord, that power is not, my lord. Power cannot be taken away by under section 20, my lord. That is giving the paragraph 30. And 31 says, my lord, these powers should be exercised harmoniously. And my lord, section 41 says, my lord, this constitutional power cannot be taken away, my lord. Although my learned friends have referred to section 44, my lord, but this paragraph, my lord, cannot be independently, my lord. This we read along with this all this paragraph, my lord. So where is answer for where is my left on my part, my lord? Kindly see, my lord. Page 17, my lord. That's your page 17.
Of the contempt petition?
A contempt of my contempt petition. That is order of this court, my lord. Relevant page, my lord. Page 19, my lord. That is our party part. Last paragraph, my lord. With appropriate for observation, the present writ petition stand closed with a direction to consider the pair of the petition. In paragraph page 19, my lord. Thereafter on next page, my lord, on this order was passed on, my lord, 16/12/2022. Thereafter on next page, my lord, Annex 3, my lord. Page 20, my lord. I file an application before the my lord, all the containers, my lord, Alice containers. That is the next application. Page 20. They brought to the notice of the Alice cover regarding the order passed by this court, my lord.
Right, you have filed here affidavit.
My lord?
This contempt petition, you have filed affidavit.
No.
Affidavit, during the course of the hearing, my lord, this issue has come up.
The limitation.
Limitation has come up by section 28 section. Then after that, the citations were given, exchange, my lord. Then since the Supreme Court is absolutely clear, my lord, section 20 will, the section 20 should be in consonance with, the act, my lord. So, within the limitation of 1 year, the content should be referred.
That is not a rigid direction, my lord.
My friend has shown the Pollov. I am relying on the Pollov set case, paragraph 44. Paragraph 44 is absolutely clear. Thereafter, Supreme Court and our High Court has also relied on those paragraph on limitation, my lord. If Lordship allows me to, I can read the paragraph 44, my lord. This is the relevant paragraph, my lord. Action of contempt is divided into two categories, namely the initiation suo motu by the court and the initiation otherwise, when on by the court's own motion. The motion of initiation of each case would be necessarily be different. While in case of the suo motu proceeding, it is the court itself which must initiate the essential notice. In the other case, initiated can only be by the party filing the application. In our opinion, therefore, the proper construction of the place is section 20. It is section 20. Must be the action, the action must be initiated, either by filing an application or by court issuing notice so motu. Within a period of 1 year from the date on which the contempt alleged to have been committed. The contempt petition filed by the applicant before the court must come within 1 year from that time. It has been, the law had been settled, my lord, in Pallav Seth case. Thereafter, my lord, there is another case, my lord, Supreme Court, and that part of the record, there is another order, 2016 14 SEC 251. Same thing has been relied by in paragraph number 10, my lord. May I read it, my lord? We are afraid that the contention advanced by the learned counsel for the appellant cannot be appreciated. Be it an action initiated for contempt under Article 129 of the Constitution by the Supreme Court or under Article 225 of the Constitution of India by the High Court. It is now settled law that the prosecution proceeding should be in consonance with the Act. So Section 20 prevails. Section 20 will prevail as held by the court in Pallav Seth case. So Section 20 will prevail, not that had to prevail. Now, another case of our High Court, my lord. Same issue has cropped up, my lord. This our High Court also relied on Pallav Seth's case, my lord. In paragraph number 4. See, same thing, yes, has been reiterated, my lord. Section 20 have to comply, my lord, in paragraph 4, my lord. Quoting the section 44 of the Pallav Seth case, my lord. So limitation will come, my lord.
So, Porua, you have relied upon which case law?
Lord?
You have relied upon some other case law?
Yes,
That is, I have.
Lord, in paragraph, on order dated 25/7, that is in the paragraph 2, my lord. That is 1995 3 GLR 169.
That was our High Court says, my lord, that petition fine under Article 215, my lord.
Supreme Court has made it absolutely clear, my lord.
That a Pallav Seth has come, my lord. This Pallav Seth was distinct in when the power can be exercised. Kindly see, my lord, what paragraph 30 has been said. Paragraph 30 has been said, my lord, the power under Article 215 cannot be abrogated, my lord. And my lord, section, my lord, kindly see, my lord, section 31 says, but it should be exercised harmoniously with section 20, my lord. That power cannot be taken away, my lord, by under section 20. And my lord, kindly see.
You have relied upon Ranjit Kumar Day.
Lordship.
Ranjit Kumar Day.
Ranjit Kumar Day.
The Ranjit Kumar Day, I have, my lord, rely on that. Thereafter, my learned has submitted this Pallav Seth case, my lord. But that Pallav Seth case, what my learned friends say, that power under Article 250 has been taken away. But Pallav Seth case has power under Article 250 not been taken away. When this power can be exercised, mentioned in that is, my lord, Pallav Seth case. Can you see that my learned friend rely upon paragraph 44? But this paragraph cannot be read independently. Kindly this paragraph read along with the paragraph 30, 31, 32, 34, 41. That my reasonable period is like my 226, my lord, although it is a discretionary power, certain limitations given, my lord, delay, lessons, my lord, alternate remedy. In this case, the 215 also, my lord, certain, my lord, restrictions is given. But this, my lord, by section 20, my lord, cannot take in absolutely taken a power over Article 215, my lord. Only what this paragraph 30 has been said. And my lord, some reasonable period must be given. But where is the left? And section 41 say, my lord, that the litigant should not be step over the matter. But where is sleeping over the matter? Immediately after passing of the order, I refer to your lordship, passing order 20 to 12.
But the agree means that you have not instituted the contempt proceeding immediately after 1 year.
No, my lord, kindly see, my lord. Teacher, you are referred to, my lord, that annexer, my lord, kindly see. That is annexer, my lord. Kindly see, my lord. Paragraph. Paragraph, my lord. Page, my lord. First, my lord, the order of this court, my lord, that I annex in paragraph page 17, my lord. Relevant to page 19. That order was passed 16/12. Therefore, on 22/12/2022, my lord, that is allotted annexer 3, page 20, my lord, I have brought to the notice of the, my lord, Ellis Contempt regarding the passive order. Kindly see. Page 20 of contempt petition. This is to inform you against the non-renewal of my service. I have prepared a writ petition before the Honorable Court and Honorable High Court by an order dated 16/12/2022 passed in so and so, directed to consider my regularization the service where I am working now. I have been enclosed herewith the photostat copy of order for your perusal and do the needful. After receiving this order, my lord, on my 23/7, my lord, kindly see the last my lord, page 20. Kindly turn to page 23, annexer 4, my lord. With reference to the above, I inform you that hearing regarding the regulation of service, nature of appointment, pay, creation of permanent retention, nomination of post sweeper, so and so, Jorhat being held by Sardi is going to be held on 15/7/2023 on 1 p.m. in the office chamber of the undersigned. You are therefore requested to present in the hearing on that day and time positively with original documents. File record for meta. I call for the, my lord, hearing. I appear, my lord. They have not done anything. There I filed the writ application. If I, my lord, step over the matter, then question is different, my lord. That what paragraph 41 has been said, my lord. Can you see, my lord?
Okay, we'll see. We'll pass the order. So, board will order. What?
The review petition is there, my lord. Let us leave it any other day, my lord. Because
Recital, this review petition number 149 of the separate.
problem.
But I'll just reply on the points which was asked by the other side. But you would recollect, the petitioner was appointed as a professor in Krishnakanto Handik Open University, Milord. Now, her services were dispensed with on 2 grounds, Milord. Just to recapitulate the facts, if your lordship would kindly come to the petition. Page number, my lord, 111. And the operative portion of the order is at 112. In pursuance to the decision of the 64th meeting of the Board of Management held on 8/12/21, read with provisions in clause so and so under chapter 6 of the first statute of the university and the terms and conditions of appointment, service of Dr. Jyotirekha G. Handik on probation as professor in Hironya Chandra Bhuya School of Science and Technology, Krishnakanto Handikoy State Open University, who is withdrawn with immediate effect because of 1, administrative reason, and 2, rejection of UGC to provide recognition to BSc General Program by letter dated 12/10/21. My lord, the 2 reason has been assigned. One is an administrative reason and other is UGC did not provide recognition to open, my lord, bachelor program. So these are the 2 reasons. Now, my lord, an argument was made on behalf of the university, my lord,
that the advertisement was modified to accommodate more candidate from science stream. Anyway, my lord, my humble reply is, my lord, in a 226 proceeding, Lordship is not concerned with the merits of the decision. Your Lordship is least bothered about why the decision was taken. Your Lordship is bothered with how the decision was taken. If a manner is prescribed for taking a decision, whether in that manner decision was taken or not. Now, the argument of the other side is on the merits of the decision. We are not bothered. For a moment, we are not bothered with the merits of decision. We are concerned in a 226 proceeding, my lord, with the manner in which the decision is arrived at. Well, I'll place one judgment on this point because these are very important, my lord. But I have not brought the whole judgment, just relevant paragraphs. Milord, this is Tata Cellular's case, Milord, 1994, 6 SCC 651. I'll rely upon paragraph 74 to Milord, 77. Please come to the second page, Milord. Judicial review is concerned with reviewing not on the merits of the decision in support of which the application for judicial review is made, but the decision-making process itself. In Chief Constable of North South Wales versus Evans, Lord so-and-so said, judicial review, as the word implies, not an appeal from a decision, but a review of the manner in which a decision was made. Judicial review is concerned not with the decision, but with the decision-making process. Unless that restriction on the power of the court is observed, the court will, in my view, under the guise of preventing abuse of power, be itself guilty of usurping the power. Why, my lord, it should be confined to decision-making process? That reason has also been given in these English decisions, which have been followed by our Supreme Court. In the same case, Lord Helsam commented on the purpose of remedy by a judicial review under so-and-so in the following terms. This remedy vastly increased in the extent and rendered over a long period in recent years of infinitely more convenient access than provided by the old prerogative writs and actions for a declaration, is intended to protect the individual against abuse of power by a wide range of authorities, judicial, quasi-judicial, and as would originally have been thought when I first practiced at the bar, administrative. It is not intended to take away from those authorities the power and discretion properly vested in them by law and to substitute the court as bodies making the decision. It is intended to see that the relevant authorities use their power in a proper manner. In so-and-so versus so-and-so, Sir John Donaldson commented, an application for judicial review is not appeal. Then, my lord, eventually Lordship will kindly come to para 77. The duty of the court is to confine itself to the question of legality. It should be concerned whether decision-making authority exceeded its power, committed an error of law, committed breach of the rules of natural justice, reached a decision which no reasonable tribunal would have reached, or abused its power. Now, my lord, what was being examined by the is being examined by your lordship is not why the decision was arrived at. The reason is why the decision, how the decision was arrived. Now, my lord, I have already submitted that as per the rules, I am entitled to 3 months notice or in lieu thereof, my lord, 3 months pay, which has admittedly not been given to me. Therefore, my lord, following the ratio laid down in, my lord, earlier decisions like the Gordon Das Vanzi, MS Gill, where the Supreme Court has said, my lord, the order needs to be tested on the grounds indicated in the order. By subsequent argument or by subsequent affidavit, you cannot improve your case. Now, here is a simple case. While discharging me, whether you have complied with the requirement of this rule, my lord, I have annexed the report. 1 second. My lord. No pity. Yes. Possibly, kindly give me 1 minute time. Yes. My lord, I had handed over a copy of these rules, my lord. This is, my lord, 1919 rules. If your lordship would kindly come to paragraph, page number 13 of that compilation, my lord. Krishnakanta Handik, Open State University employs academic service condition conduct appeal rules 2019.
Yes, got it.
Yes. Milord will kindly come to page 13. This service of a temporary 15, Milord. Service of a temporary employee may be terminated by the appointing authority without assigning any reason thereof, provided that service of an employee on probation may be terminated with prior notice of 1 month or 1 month pay in lieu thereof. So in the impugn order, there is nothing to indicate all this compliance. I have already relied upon a judgment of our High Court, Milord, on this point. That is, that, Milord, 2006 1 GLT 717. It's a division bench judgment of our High Court, Milord. 2006 1 GLT 717, para 12.
Page number?
Page number, Milord, 9.
Page
The
number
judgment is, I have given while opening my argument, Milord. 2006 1 GLT 717. Yes. Milord will kindly come to page 9, para 12. No doubt, the termination of service of a probationer is a very drastic measure taken by the concerned authority employer against the probationer. According to well-settled principle of law, when a drastic power is to be exercised, it should be safe and except according to the prescribed procedure. So this is the caution, Miller. When drastic power is given, then you must follow the procedure because you have been given authority to dispense with service of a person. So unless you follow the rule, then your power will perish. The Constitution bench of the Apex Court in Hukum Chan and so held that it is well settled that where a power is required to be exercised by certain authority in a certain way, it should be exercised in that manner or not at all, and other modes of performance are necessarily forbidden. It is all the more necessary to observe this rule when power is of a drastic nature and its exercise in a mode other than the one provided will be violative of the fundamental rules of a right of natural justice. So, my lord, the Honorable Apex Court has said in Hukum Chand's case, when the extent of power given is drastic, then if there is any procedural safeguards provided, then that procedural safeguard has to be scrupulously followed. Otherwise, my lord, that exercise of power would stand obliterated. Now, my lord, therefore, on this point, my humble submission is, I think the submission of the other side is wholly misconceived because in a 226 proceeding, as I have already replied, my lord, the Honorable Court is concerned with the decision-making process, not the merits of the decision. Why his services was dispensed with. Whether, my lord, there was something, the advertisement was tinkered with and all. And moreover, my lord, you have assigned 2 reasons. You must confine your conclusion to that 2 conclusion only. You cannot, go beyond the 2 reasons. There, my lord, I will rely upon that MS Gill's case. I have brought it. MS Gill is, my lord.
On the other day, you have submitted on this point.
MS Gill I have not given, my lord. And because I have to bring this because of the nature of the, my lord, argument which has come from the other side. Because now they cannot improve their case. Para 8, my lord. The second equally relevant matter is that when a statutory functionary makes an order based on certain ground, its validity must be judged by the reasons so mentioned and cannot be, has a lordship got it, Miller? Yes. And cannot be supplemented by fresh reasons in the form of affidavit or otherwise. Otherwise, an order bad in the beginning may, by the time it comes to the court, on account of challenge, get validated by additional grounds later brought out. We may here draw the attention of observation of Vivian Bose in so and so. Public order publicly made in exercise of a statutory authority cannot be construed in the light of the explanation subsequently given by the officer making the order of what he meant or what was in his mind or what he intended to do. Public orders made by public authorities are meant to have public effect and are intended to affect the actings and conduct of those to whom they are addressed and must be construed objectively with reference to the language used in the order itself. So order uses two reasons, Milord. Administrative reason, we do not know what is administrative reason. Other is that the UGC did not approve the BSc program. Now, my lord, here again I'll make that submission, my lord. I have referred to that regulation. If your lordship would kindly have that, just 1 minute, my lord. That UGC regulation of 2017, if your lordship would kindly come to 7 Roman 10 at page 43.
You say regulation or notification?
My lord, that's a notification, but if your lordship skips the first page, then its name is there, my lord. University Grants Commission, Open Distance Learning Regulation 2017. Next page. On top. These regulations may be called University Grants Commission, Open and Distance Learning Regulation 2017. Last time disillu to me. The losses got it, Miller.
So is it in the this notification of university grant?
Yes, yes. No, Miller, notification. I think that is the copy. I think it is a regulation of 2017, Miller. On top, page 38.
No, it is the 4th September 2020.
Oh, no. It is 23rd of June 2017. 23rd of June 2017. I say?
Yes, got it.
Yes. If your lordships would kindly come to page 43, Miller.
Yes.
Now, if your lordships would kindly come to page 42, 7. Heading is self-regulation through disclosure, declarations and reports. Now, please come to page 43, Roman 10.
Yes.
Complete information about self-learning material, that is SLM, including name of the faculty who prepared it. When was it prepared and last date, source of self-learning materials, reference of self-learning material, etc. Now, it was thought to be argued, my lord, the UGC has refused to grant approval because the self-learning materials were not ready. My lord, how can self-learning materials be made unless we appoint faculties? So 10 itself says, complete information about self-learning material, including the name of the faculty who prepared it. My lord, if this year it is not approved, it doesn't mean the road is end for all time to come. It's a continuous process. Now, my lord, an example was given by the other side that when there is no requirement of a car, why should we hire a driver? But my argument is otherwise. Here is a case, my lord, we want an automobile engineer because in the motor vehicle manufacturing plant, there is a requirement of a motor vehicle engineer. It's not a question that example of Milord driver is absolutely inept. It is inappropriate. Matter is very simple. The self-learning material is to be prepared by the faculty member once they're appointed. So once I'm appointed, then only the authority will get the self-learning material. Am I clear to your lordships, my lord? That is the ground which they have taken.
If we go to decide that issue,
No.
then we have to embark on the merit of the case.
No, not merit, my lord. Decision-making process.
Yes.
No, decision-making process is they are wrongly construing the regulation. The decision-making process, whether there is in the paragraph, if you lordship see, kindly see, my lord, Tata Cellular, para 77. Number 2, committed an error of law, para 77.
Yes, sir.
Committed an error of law. Well, they construed that self-learning material is not ready, therefore UGC has not granted approval, therefore your service is not required. Whereas, my lord, the Board of Management has already taken a decision there is a requirement of introducing graduate program, my lord. Therefore, she was appointed. And after almost serving for more than 1 year, she was discharged from service. Now, all that I'm saying is, I'm not calling upon your lordships to sit in appeal over this view. What I'm saying is, my lord, whether this regulation of 2017 has been properly appreciated. To that extent, 226 could certainly go. That there is an error of law. So this is the second point, my lord. Now, so, my lord, third point is SLM preparation is an ongoing process. Teachers do not get, unless there is no instance of teachers getting sacked for not getting approval. This year it is not given, next year it will be given. I've already shown while opening my argument, my lord, in case of mass communication, while in the initial year it was not given, subsequent year it was given. So therefore they have not terminated the service of mass communication, my lord, faculties. So it's an ongoing process and there is no instance where university has sacked a faculty for not getting approval from UGC. Because the university knows in the next year it will be coming. Otherwise, who will join? These are the two basic arguments which the other side had advanced. So I thought I must reply to these points, my lord. Now, my lord, another argument was advanced that at the relevant point of time when I was appointed, one Kondorpo Das was the, my lord, Vice Chancellor of the university. And against him, there are several allegations, my lord. In fact, my lord, my husband, when he was Vice Chancellor of Guwahati University, it was he who initiated the inquiry against him. Because in the open distance learning program in Guwahati University, a lot of wrongdoings were committed by this gentleman called Kondorpo Das. So, these are neither here nor there. So, therefore, Lordship will test the reason given in the impugn order at page 112, whether it can withstand judicial scrutiny. My case is very simple, my lord. A procedure has been prescribed in the form of Regulation 15, how you can dispense with the temporary service of an employee or a probationer. If you have complied with the order, well and good. If you have not done, then other modes of performance is forbidden. That is my basic case.
Lordship, only one thing I would like to point out, the university's conduct rules 2019 is, though it is in existence, it is not in force. That we have specifically stated in our affidavit in paragraph 16, Lordship.
Then under what authority you have dispensed with my service?
Lordship.
So you
and the reason of Lordship.
It is repealed.
No, Lordship, not repeal, but the reason for not being enforced, that also has been explained in that paragraph 16, Lordship.
My lord, a service matter, my lord, there is no discretion. It is to be governed by some rules. Otherwise, my lord, whole thing has to go back.
Yes.
That's my humble submission. Deeply.
Or sir, can children set up of the assisted like the rule.
Lordship, on the earlier occasion, Advocate General submitted, Lordship.
That is there in the order. But today you are present.
Yes, Lord.
Concluded order is that.
Deeply right.
But Mr. Soturi.
Yes, my lord.
Kindly keep the list of citation you have relied upon.
Okay.
But because
No, I'll give you that. Just now.
Judgments,
No, there are 4 judgments. I'll give you that.
Yes. But I will not rely upon those.
My lord.
I will not rely upon the written argument available on the record.
No, this is not required. Just now we'll give me, lord. Lordship, then in that case, Lordship may allow us just one day time. I will give the written argument and the citation which was earlier given, Lordship. Again.
Okay.
And tomorrow morning, together we give the thing. Deeply.
My pleasure, Lordship. The appeal is preferred by the insurance company, Your Lordship, impugning the judgment and award passed by the Lynott Tribunal, where the liability to pay the compensation was shifted to the insurance company. In the appeal, we are challenging only on the ground that at the time of the incident, the policy was not in force. The policy had expired. And if it can be seen from the record also, Your Lordship. Your Lordship, may kindly take up the TCR, Your Lordship. It is received. TCR, trial court record. Page 15 of the TCR, Your Lordship.
Page 15.
Page 15. That is the accident information report.
Yeah.
Your Lordship, the accident took place on 30/9/2013, Your Lordship. And in the AIR, if Your Lordship finds in the middle portion, Your Lordship, the policy certificate number is mentioned 3510073126200705817, Your Lordship. There it is written that the policy is valid up to 19/6/2014. If Your Lordship may now kindly come to page 62 of the TCR, that is the policy document. Page 62 of the TCR, Your Lordship. That is the policy document. At the top, Your Lordship, the policy number is there. 351007311262007055817. Here, Your Lordship can find the period of validity, Your Lordship. The policy was from 26/2012 to 19/6/2013, Your Lordship. And the accident occurred on 30/9/2013, that is after expiry of the policy. So in my humble submission, Your Lordship, the insurance company is not liable to pay. And if the claimant is entitled, then it should be paid by the owner of the vehicle, Your Lordship.
How the tribunal has dealt with the issue?
Your Lordship, the tribunal has dealt because in the cross-examination, Your Lordship, the DW, Your Lordship, on behalf of the insurance company who had came to the dock to submit, Your Lordship, in the cross-examination, he had submitted that the certificate number and the policy number are two different things. Based on only that statement, Your Lordship, certificate number and policy number are two different numbers. However, the claimant has relied on the same document.
No,
Which
in the For 54,
Lordship.
the certificate number is given, not the policy number. That is not the policy number.
It is the same number, Your Lordship, but it is the same thing, Your Lordship. Certificate number and policy number, it is same number.
And what the DW has stated?
He had stated that the certificate number and policy number are two different numbers.
In cross-examination?
Lordship. In cross-examination, he had stated, Your Lordship. However, in our evidence, we have exhibited the policy document where it is clearly shown that the policy was formed 26/2012 to 19/6/2013. And even in the accident information report filed by the police, Your Lordship, the same number is written.
Where it is observed, where it is deposed by the
In the
what?
cross-examination, it is in the PCR, Your Lordship. This number I have not written yet.
Exhibit A1. What is the exhibit A1?
A1 is, Your Lordship, it is exhibited by the claimant side.
Exhibit A, yes. Not A1. Exhibit A.
It is the policy document, Your Lordship. And Your Lordship is aware, Your Lordship, the policy is always for a period of 1 year, Your Lordship.
Yes, Mr. Thorpe.
I am appearing on behalf of the claimant, Lord.
Claim.
Yes.
That's all right. What is your submission?
Okay, this is admittedly, Lordship, on the date of occurrence, the policy was not covered. Not covered.
Then who has to pay the compensation?
Owner. And as per order dated 8/3/2021, Your Lordship, in the appeal, the service upon the respondent owner is also complete, Your Lordship.
As per
Order dated 8/3/2021. We had made a paper publication. And even the Wakalatnama has also been filed and the name is reflected in the cause list.
In respect of the other points, there is no dispute.
No, Lordship. The factual part, income part, we are not disputing.
Wakalatnama has been filed.
Lordship.
And their name also reflected in the cause list also. Lordship.
Cause
list also reflect.
owner is the respondent number 2 in this appeal.
Lordship.
Contempt is not available for the record. Where do you got it? Okay, yes, it is there. Sir, A date.
Yes, Lordship.
Yes, sir.
Yes.
Third Mr.
H. Burak, my lordship.
H. Burak, my lord, and for the Nagaland and Mr. K.T. Surkar, lord, and for the respondent number 1.
One, Lord.
Argument concluded. Judgment reserved.
Obliged.
Obliged.
Will be 10 to 30.
My lord, mainly here in this case, my lord, there was no eyewitness and nothing else, my lord. Only in this respect, my lord, I pray before this honorable court to remand back the matter, my lord, since only the claimant has been examined, and at the time of accident of the vehicle, my lord, she was at home. So on the basis of her evidence, the judgment was passed, my lord. And since this the petitioner, this claimant could not adduce any evidence, and she was at the time trauma, my lord, since her husband was expert in the accident, my lord. That is why this IA has been filed, my lord, and this under order 41, rule 27. My lord, here the letter in IA, my lord, I have stated, my lord, this some of the facts. That can I go through this IA triple 222 2023, my lord. Para 1. Just I'm reading on, my lord, so that lordship will understand that the appellant claimant file a claim petition under section 160C or MBA before the MSC tribunal, Dibrugarh, Bhait MSC case number so and so, praying for granting of compensation so and so, only due to death caused to the husband of the claimant number 1 and father of the claimant number 2 and 3. This in a motor vehicle accident, Maruti Celerio VXI car, engine number so and so, chassis number so and so, purchased on 7/12/2014. No registration, my lord. On very second day, it was the accident, my lord. By Sri Purnananda Gogoi, the owner and driver of the car. The accident was occurred on the next day, my lord, 8/12/2014, my lord. Very pathetic, my lord. At about 6:45 a.m., while late Ajit Gogoi, husband of the claimant, number 1, came back home after dropping one Sri Kukil Gogoi in Bhajo railway station, as the car was not found in order and the driver of the car could not control the steering for the mechanical problem. As a result, in the sharp turning, the car fell down in Disang River nearby Bhajo railway station and died 3 persons, including the driver, on the spot. My lordship knows the nearby the Bhajo railway station, there is a Disang River, my lord, just 60 to 70 meters away. The deceased was the sole earning member of the family, and at the time of death, he left behind his wife, the claimant, appellant number 1, and 2 minor son and daughters. The deceased was a assistant manager of Union Cooperative Bank, Sonari Development Branch, who received salary so and so, so and so. The Arunima Sangmai Gogoi, PW1, my lord, only C has been examined, my lord. PW1 adduce her evidence by way of affidavit by exhibiting the documents like post-mortem report, accident information report, form number 54, exhibit number 3, driving license of driver.
Together, 3 witnesses have been examined.
Lordship, only this PW1 has been examined. Others are not, my lord. There are 2 other eyewitnesses who could not examine, and since at the time, my lord, she was in trauma, my lord. That is why she could not manage to get this evidence, my lord. That is why I pray before this honorable court to get one more chance, my lord, to the claimant, so that they can adduce their evidence. Order this under Order 41, Rule 27, my lord, the CPC, it is clear, my lord, if otherwise, my lord, para 7, my lord, I have stated. Firstly, my lord, para 4, my lord, as the para 4, my lord, as the evidence of PW1 cannot be the conclusive, since she neither saw the incident nor she knew the cause of accident, and hence her evidence cannot be treated as eyewitness to believe her statement. She was at home at the relevant time of accident. As such, the evidence of the claimant PW1 cannot be accepted to come to the conclusion that whether driver was at fault or not while driving the vehicle. That the evidence of so-and-so has no credibility to decide the matter without any corroboration. As such, it is very much necessary to adduce evidence to other eyewitnesses for proper adjudication of the case, in the interest of fair justice, interfering with the impugned judgment dated 13/7/2017 in MSC case number 66 of 2015. But in paras 7 also I have stated, my lord, that I'm praying this on behalf of this claimant and appellant, my lord, to provide fair chance to the claimant, though the prayer was made by the concerned counsel on several occasions to adduce other evidence of eyewitness for proper and fair adjudication of the claim, but the prayer had been turned down by the learned tribunal, Dibrugarh, without assigning any reasons. For that vehicle was pursuant. My lord, only, my lord, here, my lord, these 3 cases on the same day, the same vehicle, same day accident, and this person's, my lord, this claimant's claimant and appellant number 1, her husband was expert, and in another case, the Rekha Gogoi, her husband and son was expert. So only I pray, my lord, since there is a provisions, my lord, to adduce evidence, my lord, in that regard, my lord, only I pray before this honorable court to remand back the matter, my lord. Lordship will find the judgment very.
Any police case has been registered?
Yes, there is a yes. JD number is there, my lord. Judgment of these 2 pages, Lordship may have this judgment only relying on the Lordship will find the judgment at page demand number that here I have enclosed, my lord, this claim petitions, my lord, which is at page 9, my lord, of the appeal. 9, 10, and 11, 12. up to 14, my up to 15.
Where is the GD entry?
GD entry, my lord, Lordship will find in the judgment. Page 18, 10,
No, whether you have enclosed the copy. Copy of the GD entry.
GD entry, my lord, subsequently I have got, after filing this, my lord, I have got the GD entry, the report, my lord. Lordship, kindly have a look, my lord. The policy as well as the police report, my lord. It will do. There is policy, my lord, as well as the GD entry. This police report. And the documents of the vehicles, my lord.
No police case has been registered.
Only GD entry number is there. That part subsequently, whether case has been registered or not, I do not know, my lord. When I obtained the police report, my lord, that time GD entry was there.
Yes, from the respondent side.
Item number 28, I am appearing for the respondent lordship. In this case, lordship, at this stage, lordship, order 41 rule that 27 is not applicable, lordship. As the lordship, claimant number 1, lordship, she has in their cross-examination in cross lordship, she has that I filed this claim petition, lordship. I am well acquainted with the pleadings of my claim petition and my evidence in sheet. Exhibit A is the claim petition. In the cross-examination, she has admitted that, lordship. I am the only witness in this case.
But madam, this cross-examination has to be read along with the examination in sheet.
Yes, lordship.
Where is the examination in sheet? Whether examination in sheet was discussed here.
No.
Examination of chief lordship.
Not discussed.
Yes, lordship. In only lordship. I have only cross examination part, lordship. In from that lordship cross examination.
Right.
That this lordship that
While considering the cross examination part, you cannot altogether ignore the examination in sheet.
yes, sir.
Where examination in sheet is discussed in the judgment.
Yes, sir. In the judgment, lordship. But here it is, lordship, she has stated that I have no other witness, lordship, in the cross examination. And lordship,
Maybe.
but lordship, no petition, lordship, was filed by the claimant, lordship. They are willing to, lordship, adduce any other evidence, eyewitness or other evidence, lordship. That I have checked the record, lordship, no petition, nothing was there, lordship. Now at this appellate stage, lordship, they have filed this petition, lordship, stating that I have filed an objection, lordship, against this IA, lordship. In item number 28, lordship.
Where he has stated that she has no other witnesses.
In lordship, cross examination, lordship.
Cross exam.
Yes, lordship.
You have filed
Objection, yes, lordship. But I am, this is in cross, okay, I have a record.
You have enclosed her evidence here.
No, lordship.
No.
Only case record, lordship.
Well, when you have filed objection.
Filed on lordship. On May 25, lordship. 20, item number 28, lordship.
IA.
25, 2025.
Only one IA was filed, Mr.
Yes.
Secretary.
Yes, sir. Two IAs are there.
Two IA.
Item 28. I am number 2222.
No written objection filed here.
I have filed lordship.
Well.
On 28th of May, lordship. No, not copy দিছিতো না কপি পাইছি আমার কোন ওটা কোন
Record on any.
record. I think it is not available under record.
Not available on the record.
Yes, Lord.
So that way,
Lordship. Order 41, Rule 27, double A, my lord. Double A is the provisions, my lord, where this honorable court already decided. I have the judgment, my lord, regarding this, my lord. This MSc appeal, where matter was remanded back, my lord. The party seeking to produce additional evidence establishes that, notwithstanding the exercise of due diligence, such evidence was not within his knowledge or could not, after the exercise of due diligence, be produced by him at the time when the decree appeal against was passed. My lord, regarding this, my lord, already this honorable court has remanded back the matter, my lord, only on this ground, my lord. This I had the judgment, my lord, of this honorable court. And since when there is a two witnesses, eyewitnesses, my lord, they could not be produced before the honorable tribunal. My lord, only I pray before this honorable court so that the claimant can adduce her evidences. And whatever the evidences will be there, my lord, that will be decided by the tribunal. And they will get the chance to cross-examine the witnesses, eyewitnesses, my lord, whatever it is. So, my lord, only I pray before this honorable court, since the opportunity to the appellant, my lord, may be provided, as provided
the accident took place in the year
in the year 2014.
8/12/2014.
and she has adduced evidence for the court the year 2016.
16. Now, Lordship, at this stage,
After 2 years.
now it is 11.
In 17, judgment was passed, my lord. 2017.
Our cross-examination was done on the year 8, 2016.
16.
And she stated that I am the only witness in this case and I have
No other.
My lord, these people are, my lord, they are very illiterate person. And now only, my lord, while she was not.
On what basis you were submitting that she is illiterate?
My lord, these people.
She has put her signature in
My lord, that
position form.
illiterate means, my lord, sometimes, my lord, this up to signing is not that, my lord, he or she is illiterate, my lord. Only up to, my lord, in the cross examination, whatever she said, my lord, she was not in present in at the time of accident, my lord. And how can she say, my lord? This is the case, my lord, where Lordship.
Secretary,
Lordship.
going by the examination in seal filed by this claimant, where is the deferment for this rash and negligent driving? Where?
My lord, that part, rash and negligence, my lord, they could not say anything, my lord, because whether there was a rash and negligence or not, person staying at home.
No, what is the requirement of section 166?
Yes, 160 is rash and negligence is there, my lord, and other parties there, my lord. So persons who will be the eyewitness, he can say whether there was a rash and negligence or not. Only unless and until these eyewitnesses are adduced before the honorable tribunal, my lord.
No.
Now,
the claimant categorically stated, admitted in her cross-examination that she is the only witness and she has no other witness.
Yes.
Now, where the
Question of
witnesses come from?
no, that no other witness means I do not know no other witness, but there are a witness, two witness. One is, my lord, one is, yes, one is
No, Mr. Secretary,
Lordship.
Here the police has submitted one report.
There are two witnesses, my lord.
No. You see, from the report, You
Yes.
have submitted today. There is a police report
Lordship.
where it is stated that during investigation, it is found that on the date of accident, the owner of the vehicle accidentally met with an accident.
So there is no ration.
During investigation means the officer in charge Sunari police station might have examined some witnesses.
No, my lord, this police also not examined, and this the report submitted by
And
the
the GD entry is also not part of the record.
that may be called for, my lord. That can be called for by this honorable court, my lord. Because whatever I have the record, my lord, that much I have, my lord. That is why I have placed before this honorable court. And if any other record is required, my lord, lordship may call for this record, my lord, which are necessary.
It is your claim petition, it is your appeal.
Lordship.
GD entry number 190 of 8/12/2014.
My lord, that lordship, as per the this form number 54, my lord.
There only the number is given.
Yes. And there is a no FIR also, Lordship.
No FIR.
That's why, Lordship, no police case, Lordship. Only GD entry.
And in my case, Lordship,
No.
if they want to prove ration negligence, in my case, they do not get any compensation. Because for the ration negligence of this person, he recently Supreme Court has made it very clear. The Karnataka High Court judgment was upheld by Apex Court, in which it was said for their own ration negligence driving of compensation cannot be given under. And earlier also, Juma Saha case,
No,
And
that
Lordship, it is not a question of right, Lordship, order 41 will. I have this judgment, Apex Court judgment, Lordship, Ibrahim, 15 judgments, Lordship, paragraph changed by. It is not that we just, they themselves in tribunal say something, now they want to correct it. It should not be allowed that.
No,
That-
on
that-
merit point, I'm not coming, my lord. Only I am coming before this honorable court right now, my lord, regarding remanding of the matter on the basis that lordship.
Remand cannot be made routinely.
Yes,
You have to assign reason.
yes.
Now, if that being the position, my lord, if lordships ask for this police report, then I have to.
Please, we are giving you time.
Lordship.
You produce GD entry number 190 of Sunari PS case number of Sunari PS dated 8/12/2014.
One,
Mr. Secretary,
Lordship.
Learned Counsel for the appellate. Also heard Ms. D.D. Corman, Learned Counsel
So
for
let's
the respondent in
I
MSC case number.
MSc appeal, or yes, appeal
MSC
number
appeal number
258, Lordship. Item
258.
18.
Then Madam R.D. Mazumdar in
MSc Appeal 291/2018 and 319/2018.
9/1 of 2018. Then
319.
3/19 of 2018. 18. In the course of deliberation, it has come to the notice of this court that in connection with the accident in question, Sunari PS has registered on GD entry being GD entry number 190 dated 8/12/2014. The said GD entry was not made available before this court. So Secretary submits that it may be granted some time to obtain a copy of the said GD entry and to place the same before this court by filing an additional affidavit. Accordingly, the pair allowed the less the matter after 2 weeks after it is
Lordship.
And your blessing.
And Lord-
You can take this document.
Lordship,
If it-
And Lordship, I have filed the objection, Lordship, that maybe in the
Okay. Thank you.
Register it.
Consider it. Okay.
ob-
This is for the post of assistant professor of college, my lord. Advertisement was issued. Accordingly, the selection process was also completed. Then thereafter, my lord, they have cancelled it and a retender was, another notice was issued. So we are before your lordship only to say that there was no reason for re-advertising. And the
Earlier advertisement was cancelled.
not cancelled.
Then without cancelling the earlier advertisement, how can the post
They
get
have done-
the advertisement?
And I'll just put the place facts correctly, man. And page 21, your lordship. This was the advertisement issued for assistant professor of botany, English, statistics, and assistant professor science, political science. So I am here in political science. Number of posts through, one is for SC, so I am for the SC. And accordingly, my lord, I am duly qualified, page 22, your lordship will get it, my lord. Where a call letter was issued. As your lordship got it.
Page number
22.
that's all right. Then how the next process is initiated?
Madam?
How the second advertisement was issued?
Issued because after the cancellation, they have taken a decision for reissue. That I'll come. I'll come. That is at page 31. Subject sensitive and personal. I'm directly requested to take necessary initiative to conduct a fresh advertisement. Sorry, well, this decision was taken and this decision was challenged before this court.
What is the decision?
That page 31. Advertisement to issue, am I? This decision was challenged.
No, what is the decision?
Page 31.
31 is the letter.
Letter and the decision is page 27. Oh, sorry. Oh, sorry, the page 26. 26. Fresh interview be held for the post of assistant professor in political science. All other posts have been filled up. Cancelling the interview held on 19/5/22 as the said interview remained inconclusive owing to the sudden suspension of all activities under Assam University, Silchar, Jorat, so and flood havoc of the adjoining localities, that is in Kachar. Before that, your lordship will kindly see page 25. After the holding of the interview, they have issued this. Process of interview for the selection of assistant professor of political science remain inconclusive owing to the sudden flood havoc in the adjoining areas of Hailakandi and the suspension of all activities under the Assam University Silchar. As all the members of the selection committee had to leave the college instantly owing to the reported disruptions of the road communications, it is decided to hold the same interview after restoration of the normalcy, observations, all necessary formalities, etc. So then thereafter they take a resolution for re-advertising. But they have already completed the whole process. They know who is the selected person.
petitioner is received. And additional affidavit, your lordship, is page 42. The flood was in the district of Kachar. Page 42.
Can for that ground they can cancel the.
That is what they have done. First they have postponed it, and they said for the purpose of
Who is
that
appearing for the
19.5 with 22.
who is appearing for the college?
Yes, I will.
Only the process has been completed. I would like to show that.
What process can be cancelled?
My lord.
Can
No, we have,
this ground
your lordship
process can
kindly
be
see, my lord, what happened. Then that day, my lord, when the interview take place, my lord, only out of 14, my lord, only 4 candidates were appeared. There is a havoc in the entire district, my lord. There is a flood situation. We had everybody, all the interview person, my lord, person in the selection board had leave the place. It was inconclusive, my lord. So it is inconclusive, my lord. That's why, my lord, your lordship kindly see, GB, after had be a discussion, GB has taken a resolution. GB has taken the resolution, and that resolution was sent to the my lord government.
No. CP cannot take such a decision in that manner. On that ground cannot cancel it.
No, your lordship kindly see, my lord, that resolution of the governing body, my lord. I'll place the record, my lord. That is,
No, it is
now, my lord,
part of the record.
my lord, your lordship kindly see, that is not been done, that is not been challenged, my lord. What they have challenged, my lord. Thereafter, my lord, they file a complaint before the director. They file a complaint before the director. Director, after hearing both the parties, all parties, my lord, passed an speaking order, my lord. Their order has been not been challenged, my lord. Thereafter, my lord, this second interview, my lord, they are asked to go. The director, secondary higher education, my lord, passed the order to go for press advertisement, my lord. So, my lord, after hearing, my lord, the order was passed, my lord. That I have annexed in the affidavit, my lord. That is not been challenged till today, my lord. Page 75, your lordship kindly see.
Put it in page 53, man. It is there.
Page 75, my lord. Because he lodged a complaint before the director, my lord. So, as per the direction of the director, my lord, we are go for the, my lord, press interview.
Page number 70.
5, my lord. Page 75, annex 6, my lord. Type copy. Originally 78, my lord, I have given a type copy, my lord. Hearing, may I read it, my lord? Has your lordship got it, my lord?
Got it.
Hearing the connection with the interview for the post of assistant professor, Department of Political Science,
Operative portion of the order.
my lord. Page 77, my lord. Further, governing body of the college has adopted a resolution number 5B of the dated so and that fresh interview to be held for the post of assistant professor of political science, cancelling the interview held on 19/5/2020 as the said interview dated so remain inconclusive owing the sudden suspension of all the activity under Assam University Silchar jurisdiction under dated so in the flood havoc adjacent the local authority of Hailakandi town. On scrutiny of the above report received from the Principal SS College, Hailakandi and pursuant to the resolution number 5B and dated so adopted by the governing body of SS College, Hailakandi, it is decided to request the Principal SS College, Hailakandi, to take a necessary initiative to conduct a fresh advertisement and interview for the post of assistant professor in the Department of Political Science reserved for the STSC so and so. Hence, the petition dated so is hereby regretted. So that order is not been challenged, my lord.
So that was the order passed on their application, my lord, after hearing both
But
parties.
the fact remains that the earlier process was not
Not
taken to the
conclusive, my lord.
logical conclusion.
Not concluded, my lord. And by this time, my lord,
No, that's all right, but whether in this manner, the selection process can be cancelled. No,
the selection was not completed, my lord. There is,
maybe the process was cancelled.
my lord, process was cancelled, my lord. Even lordship kindly see that resolution.
So we have to examine the decision of the governing body.
My lord.
They
No,
have taken the decision.
but
to cancel the
why I am submitting against that, my lord, that we refer the matter to the director. We refer the matter to the, because without the approval of the director, we cannot do anything.
Original decision is taken by
The governing body.
governing body.
The
And
governing body is taking a decision, my lord, because probably, my lord, out of because of the flood situation, my lord, all the candidates are unable to appear, my lord. Only 4 candidates appear, my lord. He is the only candidate remain, my lord.
well, why subsequently the interview could not be held?
Subsequently, my lord, we right, yes, subsequently it has not been held, my lord. But by this time, it is already, my lord, it is too late, my lord. That's why we, what to do, I asked the director, my lord. Then because of the director, direction, my lord. This direction is by director.
Mr. Das,
Yes.
very recently, about 1 week or 2 weeks back,
Yeah.
Supreme Court has delivered a judgment on this point regarding cancellation of the selection process.
I'll look into it.
Abruptly, what is that decision?
Yeah.
I,
Those are also.
I have gone through it, but I have not remembered the citation. Very recent. What is it? We keep the matter as.
Only thing that your lordship will tell you is what the director has said. Page 54, your lordship will tell you. Is that director report only?
We are not concerned with that.
Yes.
Because the decision to cancel the process was taken by the
Governing.
governing. Art, sir. It is that's by sir. DJ Monto learner.
I am for the, my lord, respondent number 4 and 5, my lord.
RS already product respondent number 4 and 5. Mr. Tobilder for number 1, 2, and 3. 1, 2, and 3. Third in part, please the matter on. What matter the last?
Before vacation, it will be a problem, my lord. From next week, almost 1 days, my lord.
Then immediately after reopening.
My lord.
On 16th or 17th? 16th. That's the list the matter is started.
Deeply.
My lord, in this matter relates to pension, family pension dispute of two wives, my lord.
Not two wife.
Oh, sorry, a wife and the
Daughter.
daughter of co-wife, daughter of co-wife. Here in this case, my lord, lordship has instructed us to make attempt to compromise the matter about the amount, what amount we can pay and what amount she is agreed to accept, my lord. My lord, earlier, my lord, our instruction was that she is able to pay 12,000 per month. And on our request, she agreed to pay rupees 13,000 per month. Their demand is 15,000. So this is, and we have filed affidavit. They have not filed any affidavit. This is the position.
13,000.
My lord, he's undergoing degree course in a college by reciting the petition in the house of the petition.
May I submit, my lord?
True, my lord.
13,000, my lord, the matter may be settled, my lord. So ultimately, the issuing surviving of the daughter, my lord, that was settled, my lord, in 30,000, and with the area, my lord, from 2021, pension is not paid. No,
We have also not paid any, received anything.
Yes, my lord. From 2021, my lord, it was yes, my lord. Because it was not paid, because there is a stay order operating in this case, my lord.
In view of the order.
Lordship may kindly have a look at the order dated 25/10/2021. And by that order, there is a stay, paragraph
Yes, ma'am.
7. Nine? Stay. নয় 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 ইয়ার পরে বন্ধ My lord.
File one affidavit stating that both the parties have settled the matter, and on the basis of that affidavit, we'll pass the order.
My lord.
We'll close the date petition.
My lord. My lord, we file affidavit on 29/5/2025.
No, regarding the settlement.
My lord, we have agreed to pay rupees 13,000. They have not filed any agreement. Joint lordship is asking for joint affidavit. Well, if he is ready, then we can file. Huh? No, yate unnecessary ke delay hoga like.
File a joint affidavit.
Yes, ma'am. That will be better, my lord.
Pardon, sir.
MAI Hussain.
MAI, sir, pardon. Sir. Signature, pardon.
On behalf of 9, my lord.
Sir, you saw the form?
And for the respondent number 2, 3, and 4.
Respondent number 2, 3, and 4. 5. That is 4 for 1 and 7. Third part, place the matter on.
That will be, well, my lord, delay, my lord, the period pension is, my lord, suspended, my lord.
Minutes no opening, my lord.
The next week, my lord. Lordship.
Affidavit, then we'll close the matter.
My lord.
On the basis of that.
My lord, lordship may mention that we are agreed to pay 13,000. They are also ready to accept, my lord. On that basis, the joint affidavit.
You prepared the affidavit.
My lord. My lord.
During the course of deliberation, it is submitted that the parties are agreed to settle the matter, and they will be filing an affidavit on next day. There is according to the law, it's the matter of
Deep lovely.
Item 32.
It is a lordship. The matter pertains to non-payment of salary to the petitioner. The lordship may kindly start from paying annexure 6, page number 46, whereby the Commissioner and Secretary of Assam Education Department, as per GOV order dated 9/8/2005, directed regularization of services of all the. May I read your lordship?
But where is the purpose?
Finance has submitted their affidavit stating that the record relating to the WT message has been taken for some inspection, and so lordship kindly peruse the affidavit filed by the finance.
Whether the presence of respondent number 3 is necessary or purpose?
Yes, ma'am.
Is present.
He was present, but now available or not, but
Where is the order of passed by this court dated 28/8/2005? Is
No.
part of the record?
28/8.
Yes, 2005. Have you annexed that order here?
Twenty-eight, 2025.
Yes.
Oh, sorry,
For
2005.
for-
28, 2005.
Yeah.
Lordship, page number 47.
47.
Starts from page number 47. And my name is at serial number 36, page 50. And I have been adjusted to the school, Lokhi Nagar Tribal ME School.
Your name is that serial number?
36, your lordship. Page 50. Hold on. It's a high point of 87 affair. Now it's the additional equipment. It's only any difference.
So after the order of this court dated 5/5/2022, you have filed a representation before the respondent authorities.
Lordship, 5/5.
2022.
Lordship, in this case, we belong to the list of 28 2005, and we have annexed an order passed by this honorable court. I was not party to that case, but we have prayed for a similar order, at least one-time measure. As an one-time measure, my documents in the same footing. At least I may approach the department, as it has been stated that illegal stroke irregular, because there is a difference between illegal and irregular. Certain of decisions of the Honorable Supreme Courts are there. So with the same prayer at that time we have filed, along with that we have submitted on working certificate stating that at that time I was working at the school. So subsequent to that, two affidavits have been filed. Education department admitted my appointment, my regularization, but at para 6, the department stated that due to for the WT message, the payment were at that time stopped and no payment till to date has been done. And thereafter, as per Honorable Court's order dated 17/5/2024, Finance Department filed an affidavit stating that this record is para 4 of their affidavit. Page 116, Your Lordship. In this regard, further state the Office of the Additional Director General, CID Assam, Ulubari, requested Finance Department write their letter issued, memo number so-and-so 8/9/2022, to produce the original file containing the WT message.
Now tell me, your service has been regularized.
Service were regularized in the year.
Now you are getting salary.
We are not getting any salary because we have been stated without any document annexed, but their statement are made that our services, although appointed irregular at that time, regularized by the department.
With effect from?
Lordship.
Regularized with effect from?
2005, Your Lord.
2005.
Yes, 2005 order, annexure 8 that has been annexed, and
You are not getting salary.
Lordship, on the last occasion, I have stated one affidavit we have filed on 23/2025, where from the same list, serial number 9, name whose service was also regularized in that list of 193 teachers of the Kachar districts whose services were regularized, subsequently stated illegal or illegal stroke irregular, but his service has been in the year 2021 has been.
No, you tell me your service has been regularized with effect from the year 2005.
Yes.
And since then you are not getting your salary.
No, yeah. On the ground that our appointment was illegal and irregular. The department has been in the same footing, illegal and irregular, although there is a difference in between two terms.
Yes, madam, if the service of the petitioner was regularized, then why salary was not paid?
Lordship period, my lord, 82, my lord. 82.
It 82 is the part of affidavit.
Part of affidavit, our affidavit, my lord. Annexure 1, my lord.
Annexure 1.
1. A, my lord.
Annexure 1 is the 80 page number. Annexure?
Annexure A, my lord, page 82.
The affidavit filed by the respondent number 4.
Our affidavit, annexure A, my lord. Affidavit by respondent number 4, my lord, director.
Respondent number 4.
Respondent number 4, my lord. Only one annexation is here, my lord.
Here, WD message.
WD message, my lord.
Yeah.
This is issued by my Lord, Deputy Secretary to the Government of Assam, my Lord, Finance Budget Department, Dispur, my Lord. May I read this, my Lord? It has came to the notice of the Finance Department that fake appointment of teachers in Kasar district has been made on the strength of cabinet decision of 24/2/2005 with reference to the recommendation of the Monohran Committee. In view of the above, you are instructed to entertain the list of presented on the strength of the letter number so and so until further instruction from Finance MSG over.
Thereafter, what happened?
Thereafter, my lord, the financiers filed their affidavit, my lord, in page 116, my lord. Their affidavit, para 4, my lord.
That is there, but what material is with you to stop the payment of the petition?
Because on the basis of, my lord, this WT message, my lord, we have stopped, my lord. Because here, my lord, it is specifically mentioned, my lord, the persons who were appointed, my lord. Fake appointment, my lord. It has came to the notice of the Finance Department that fake appointments of teachers in Kasar district has been made, my lord. Thereafter, the records were seized by the now, my lord, records are as per the affidavit of the Finance Department. It is the custody of Additional Director General of Police, my lord, CID Assam.
Can it be said that his regularization order is illegal?
That is not challenged after regularization, so far my knowledge says. Because the additional affidavit we have filed, the of the same list, person concerned some and Sudhir Kumar Sinha, serial number 9, his service in the year 2021 has been regularized. If that be so, then entire list is to be irregular or whatever their ground is. Now, my submission, another submission is before your lordship. This kind of cases, plenty of cases were pending before this honorable court. Recently, 2 judgments of the coordinated judgment, otherwise, these people are given a chance to appear before the concerned authority for verification of their document. Then department will take account of and they will take a decision.
So that after verification of document, your service was regularized.
Yes, sir, Lord.
Then
These 2 judgments are there, otherwise also.
unless there is material to show that the regularization order is illegal, why the petitioner should be again subjected to?
And Uma Devi's judgment is also there, your lordship. It's a settled judgment. where a person, either any mode he has been appointed, if he works for 10 years or more,
No, Lordship. Lordship, I may, if it's a fake appointment, Lordship, Lord wishes all contracts, Lordship, Uma Devi won't be applicable, Lordship.
That's all right, but you see, as per cabinet decision, they have been regularized. His name is there in the serial number 36,
But
page
if,
number 50.
if you lordship peruse the WT message, my lord, then on the basis of that cabinet decision, my lord, fake appointments were also issued, my lord.
no
verify
cabinet
my-
decision, anything that has been annexed would have been annexed with the affidavit.
No, on the strength of my lord cabinet decision, they were regularized.
They are not
Now
aware
they
of any
cannot-
cabinet decision or anything.
Whether that cabinet decision is available or with you.
But if you lordship peruse page 47, their regulation order, my lord. Please claiming, my lord.
47.
47, my lord.
Yeah.
Here, my lord, it is specifically in exercise of the power conferred upon the Director of Elementary Education, Assam by government letter dated so and so, pursuant to the government under memo number so and so, issued on the decision of the cabinet decision meeting held on 24 to 2025, my lord. For the regulation of the services of 2,776 numbers of LP, ME, MEM, ACS school. On the basis of the cabinet decision, my lord, their services were regularized.
Of the entire Assam 2776, and out of that,
Perhaps with the cabinet memorandum
Well,
prepared for the meeting held on 24 to 2005,
well,
the list of candidates might be there.
well,
If you produce that cabinet memorandum,
Lordship, if I may, Lordship, can this matter be referred to for mediation, Lordship, where all the authorities can sit with the petitioner once and Lordship, if there's any scope of and Lordship, and if it doesn't happen, Lordship can always, because
no, it cannot be settled in the mediation.
there's some Lordship
So
where.
the issue is serious.
Yes, Lordship, that I admit, Lordship, because here the records regarding the appointments and all have been seized by the police authorities, because of which there's some difficulty in the verification. And if someone similarly situated is, which my learned friend is saying that someone similarly situated is still getting their salary, Lordship. Maybe. Lordship.
No, let us see one thing. You produce the cabinet memorandum prepared for the meeting dated 24 to 2005. Then whether Madam Bormon is available.
government.
You know, obtain the status of the page number 103.
149. Government 49. Government 49. Government 49.
About the status of investigation in respect of the file number WP194 of 2005, seized by the Additional Director General of Police CID. That's all right, but can you obtain instruction in respect of the status of this file? Part It's Dasgupta Learned Council for the Petitioner. It's here for
Elementary education.
number. That's what I think implemented education department, subsolid for finance department. Then you are not a party. Department. After hearing learned counsel for both the parties, perusal of the cabinet memorandum prepared for the meeting held on 24 to 2005. In respect of regularization of service of 2,776 numbers of LP, MEM, SS, HWS research. Is found to be necessary, and accordingly, it is provided that it should be a learned learning council for the elementary education department shall produce the cabinet memorandum prepared for the meeting held on 24/2005 before this court on next date. Madam, you see, after this cabinet meeting, one order was also passed on 9th of August 2005 regarding regularization of excess research.
Right. But this WT message is in regard to Kasar district and petitioner is fall under the Kasar district.
That's all right. We'll see whether his name is there in the
Right.
cabinet memorandum or not. That order it is provided that Ms. Kumar, learned government advocate who is present in the court, shall obtain instruction in respect of the file number WB194 2005, which was seized by Additional Director General of Police, CID Assam. On next day. That applies this court on next day.
May I pray for a order? Copy of the order.
Copy of this order. The furnished to Ms. Kumar during the course of the day.
Lordship, after vacation.
After vacation. This is a list of matter after vacation. That's part.
May I please, Lordship?
Yeah.
My lord, in this case, my lord, impugn order, your lordship will find my lord at this 170 million.
Page 100.
70 million.
Yeah.
My lord. Findings, my lord. May I read, my lord? It is seen from the record in the year 1995, some teachers were appointed in the Bhansar LP School under Bodo Autonomous Council, Bodoland Territorial Council as statutory teacher at rupees 900 per month with so and so. The petitioners of WBC numbers also received their monthly salary with effect from 1/11/1995 to 4 1997. That is for 18 months only. Then after their salary was stopped, the petitioners approached Honorable High Court by filing WBC numbers also, and the Honorable High Court disposed of the case with direction that the respondent authorities to scrutinize the claim of the petitioners and thereafter pass an appropriate order. Since the grievance of the petitioners was not considered, the petitioner filed another petition by WBC number so and so, directed the respondent's authority by order dated so and so, the petition disposed of with the direction that the Commissioner and Secretary shall pass the matter, place the matter before the court appointed committee, and said committee shall consider the case regarding their arrears stipend from May 1997 as directed by the court by its common judgment under Dr. Spencer. Report of the Director of the BTC, my lord. In this connection, Director of Education, Borderland Territorial Council, Kokarasar, had informed by letter number so dated so that the grant in aid teachers are engaged at various Spencer LP school in the year 1995-96 by the then Deputy Inspector of Schools, Nalbari Kokarasar, Professor non-existence and non-sanctioned post as per policy decision taken by the erstwhile BSc. The school have received grant in aid for few months and discontinued. The said engagement of the teacher as grant in aid was made with a condition that the erstwhile BSc would not bear any financial responsibility and or order of granting aid be cancelled at any time without giving any notice and without showing any reasons thereof. In this connection, as reported, the BTC authority has not taken policy decision for granting stipend grant in aid with those franchise schools. The present BTC government has not taken any policy on the scheme initiated previously. The then expelled BTC in the 1995. Now, my lord, order, my lord. In view of the above facts, the claim of the petitioners cannot be considered due to the following grounds. The petitioners have not been vigilant with their case and they have raised their grievance after a delay of almost 14 years from the date of disposal of the earlier petition. Between this year, so many criteria and qualifications are notified by the NCTE for recruitment of teachers in elementary schools. The claim for provincialization of the teacher and their service as teacher of LP school as per Assam Answer Educational Institution Provisions so and so has been struck down by the Honorable Guwahati Head. Therefore, the claim of this regard is no longer tenable. Director of Education, Borderland Territorial Council, Kokrasar, had informed at letter number so that it's not granted teachers engaged at various Answer LP schools in the year 1995-96 by the Deputy Inspector of so-and-so, non-section post as per policy decision taken by the erstwhile BSc. The school have raised grant in aid for few months and discontinued. The said engagement of teachers as grant in aid was made with condition that the erstwhile BSc would not bear any financial responsibility in order of grant in aid be cancelled at any time without giving any notice and without showing any reasons thereof. In this connection, as reported, the BTC authority has not taken policy decision for granting stipendary grant aid to those cancer schools. The present BTC government has not taken any policy decision initiated previously. It then is told this area. My lord, petitioners were appointed, my lord, by the BTC authority, my lord. My lord, finally, page 37 is my lord, appointment order, my lord. There is no such, my lord, condition raised and reflected in the appointment order, my lord.
Do you have any document to show that earlier you have received the stipend?
My lord. Yes, we have
document to show that you have received the stipend earlier.
We have stated, my lord, in the repetition of my lord.
Any document?
No, my lord.
Except the statement made in the repetition, do you have any other document to support your claim?
No, my lord. No other such documents is available. In fact, my lord.
The last part of the order at page number 171, where it is stated that the PTC authority has not taken policy decision for granting stipendary granting aid to those venture LPs.
My lord.
The present PTC government has not taken any policy on the scheme initiated previously by the then erstwhile BSE in 1995.
Yes, my lord. So, my lord, we
So you show me that there was a decision taken by the erstwhile BSE in 1995, and that you have received some grant in aid.
my lord, kindly see please 42, my lord. May I read, my lord? Bodoland Autonomous Council is pleased to accord sanction not exceeding rupees 1 crore 90 lakh so only from 1993-94 plan fund received from GOV of Assam to the Director of Education, Bodoland Autonomous Council for payment to the teachers with effect from 1/11/1995 as per order of the Bodoland Autonomous Council guide and number so and so payment to the teachers be met with proper scrutiny records. The above expenditure will be made from council's own fund received from the Government of Assam under head so and so deposit personnel deposit PSC and adjustable under head 2092 general education 102 assistance to non-gov primary schools out of grant in 8 for the year 1993-94 primary education plan.
So there was a decision.
Yes, my lord.
Yes, Mr. Bora.
It is challenging the order of the direction of the secretary, my lord. The state of Assam, my lord.
Lordship, insofar as the
Which will come later on, my lord.
order under challenge is concerned, Lordship, that the last paragraph which your Lordship has again, Lordship repeated, that in this connection, the report of the BTC authorities. In this connection, as reported, the BTC authority has not taken any policy decision for granting stipend, granting aid to those venture schools. The present BTC government has not taken any policy decision. Therefore, the policy decision has to be taken by the BTC. So the government's role is limited. Once the policy decision is taken by the authority, then only.
This order, page number 42, annexure 6.
Annexure?
6.
No, that was for the. That order was 46.
42.
42. That order was passed in 1995, Lordship. That was there. At that relevant point of time, BAC had taken the decision to provide grant in aid. But subsequently, Lordship, this is what it is specifies, Lordship. If your Lordship peruses that in this connection, as reported, now it is the BTC authority. The order impugned, Lordship, in the last paragraph. In this connection, as reported, the BTC authority, the present authority, has not taken any policy decision for granting stipend grant in aid to those venture schools. The present BTC government has not taken any policy on the scheme initiated previously. That scheme was initiated previously by the BAC authority. Previously by the then erstwhile BAC in 1995. So that page 42.
This scheme was initiated as per order. This order, annexure 6, page number 42.
42, Lordship.
42.
Lordship.
Sir, you have withdrawn this scheme
That
by the BTC.
That has not been continued by the BTC.
Where is the resolution?
That has to be provided by the BTC authority, Lordship. Because that policy has to come from the BTC. It is not the government will.
No, can the policy decision taken by earlier government?
Because if your Lordship.
Done by subsequent government.
If your Lordship sees that page 42 also, this order was also passed by the Secretary, Bodoland Autonomous Council.
That's right.
Lordship.
There was a decision.
Lordship.
and they have also been granted.
Lordship. They have
Cited.
the Lordship in 1995 it was granted.
Yeah, but subsequently, where is the resolution to show that this order was withdrawn? This scheme was withdrawn
That perhaps has to be
by the PTC.
provided by the BTC. It has to be provided by the BTC.
No, no. What it reflects from the order of the Concerned Secretary, my lord. Before this, there was a scheme, my lord. And for that scheme in page number 42, if amount of 1,90,000 rupees, 1,90,00,000 rupees has been granted. And in the imperial order, lordship will see in the very beginning itself, my lord, these petitioners are getting 900 rupees per month. And they have received the amount till with effect from 1/11/1995 to 34/1997. That is 18 months they have received it. So that amount has come only for that particular period and that has been released and they have received it. And the further scheme, whether it is, there is no policy decision, that is a fact, my lord. There is no policy decision. The order itself reflects that there is no policy decision, but this scheme, whether it is, that means reflect that the policy, that is,
Whether that scheme initiated by the erstwhile BSc
BSc.
authority is discontinued.
That instruction I don't have it, my lord. That, but there is no policy decision to regularize or something like that, my lord. To
Scheme earlier initiated has to be discontinued.
Discontinued.
By an order. That the
by order means
present authority
by
decided not to continue with the.
when the finance is involved, my lord. BTC has no finance is not the finance is not the subject of the BTC, my lord. Everything they get it from the state of Assam, my lord. Moment the finance is involved, my lord, we have to take the grant from the state government. That amount has come, it has been released. That's a fact, my lord. That for 18 months they have received it, and for continuing it, the scheme there have to be from the finance. That amount should have to be from the state of Assam, my lord. That instruction.
No, that's all right. It is not your case that the government has not provided fund to you and therefore you
In 1995, the amount has been provided, and for that for 18 months period, it released.
Why it was stopped or discontinued?
That instruction I don't have it, my lord. That instruction I don't.
When such a decision is taken, and if taken, you produce it.
My lord. Another fact, my lord, also will see, my lord, the payer. They have come before the court after 27 years. And
Now,
that decision of the Honorable Court, my lord, the division bench decision, my lord, they cannot claim area salary, then they are claiming an area salary beyond the period of 3 years, my lord, from the date of institution of the case, my lord. So this petition has been filed in 2023. The division bench decision.
we are approaching before this court, my lord, since 2023, 2003, my lord. Till that's, my lord. My lord, in the earlier occasion, my lord, kindly see that delay has already been considered, my lord, already been condoned, my lord, by the earlier petition, my lord. Now, my lord, they are raised.
Mr. Bora, there is a decision of Supreme Court, not only a single decision, but a series of decisions that in this kind of cases, the cause of action continues in every month. Because their right to stipend or right to salary accrues in every month.
Well, that's on the different facts and circumstances, my lord. Here, they should have come it early, my lord. And these are all division bench decisions based on Supreme Court decisions.
Maybe division bench decision cannot override the decision of the Supreme Court.
No, I'm done. The division bench decisions are based on Supreme Court decision, my lord. I will show it, my lord. On the strength of the Supreme Court, our division bench decision has come, my lord. But at the same time,
you bring that,
I will get that whether the scheme has which has started, whether it has how it has
discontinued,
why it has discontinued.
Discontinued, and if there is any written order,
Lordship.
pardon me, sir.
Yes, sir.
And Mr. Yes,
number 2 and 3.
As for the
Upon BTC authority.
So Tolia is there?
Respondent number 6.
So Tolia for respondent number 6. After hearing learned counsel from both the parties, which permitted that Mr. Bora learned standing counsel for BTC shall obtain necessary instruction that to when the scheme started by stream of providing stipend the Venture LP School initiated by the arts-wide BSc Modular Autonomous Council Proposal by order dated 1st of November 1995 was discontinued or still in court. Then appraised this court on next addresses the list of matters after vacation.
Lordship. My lord, immediately after vacation.
Immediately after the
Lordship.
vacation.